Welcome to Crestview Community TV's Court TV. I'm Ryan Hardy, your Crestview Community TV legal analyst, and today we're watching a miscellaneous court date / VOP court date. You're going to see, by VOP we mean violation of probation, and you're going to see a lot of people this morning who are, a lot of them are going to be incarcerated because they violated their probation. When you violate your probation, you're not entitled to a bond. Doesn't mean you can't get one, it means it's harder to get one. On a new law violation, most people are entitled to a bond, absent some major circumstances. When you violate that probation, though, you're not entitled to a bond, but you can get one. But that leads this court date to having a lot more inmates. Now, when you're called to the podium, a couple things you can do. You can enter a plea to your VOP and say, yes, I did it, I violated my probation. And you can get sentenced. You can ask for a continuance. Let's set this down the road, maybe try to work out some details, maybe try to work out a deal. Or you can ask for a contested VOP hearing, which will be set at a later date in one of the afternoons of this miscellaneous date. Now, VOP hearings are very hard to win. It's a different standard of proof. We don't see a lot of them because it's rather easy for the state to prove if you violated your probation or not. So you're not going to see a lot of contested VOP hearings. Now, in addition to the violations of probation in the mornings, you're going to see some other smaller, shorter hearings, things like bond hearings, or things that don't take a lot of time, normally 15 minutes or less on these morning hearings. Anything longer than that is going to be set to the afternoon.
Mr. Durrell?
Your Honor, I'm going to have to pass. My client is downstairs in security right now, and I can go over some things with him before we're ready.
That's fine, Mr. Rare.
Thank you, Your Honor.
Morning, Your Honor. And she's fixing to come out, Judge.
Which client do you have?
It's under the Lupella firm, Judge, Nicole Bola, B-H-O-L-A.
It might be listed as no attorney on the docket that you have.
It is,
What's the
Judge.
name of it? Bola?
Bola, correct. We just filed notice yesterday.
It was no attorney.
We just filed notice yesterday, so it might not have updated on the court's docket.
Okay, thank you.
Your Honor, we're here today for VOP first status hearing date. There is a new felony case that's currently set for August 14th on the court's pretrial. For purposes of today, we'd like to bump this to the August 14th also to track. Additionally, we do intend to file a bond motion for the court's consideration. In talking with the state, I believe the court's next miscellaneous date would be July 11th. Would the court allow us to go ahead and set that VOP case for July 11th at 2:30, and we'll get that filed this week?
What, for the bond?
For the bond hearing.
Okay. 11th or the 18th? We do the 18th, July 18th.
We can take that, Judge.
Okay.
And if I could, does the court
And you
have
want to come back on and track it with the regular pretrial on August 16th as well?
We can go ahead and do that, Judge, just to make sure we have that track date. If we need to change it on the 18th, we can. Give me one moment, please. On the 18th, will that be at 9 o'clock, I assume, Dr. Judge?
That would be in the afternoon.
2:30?
Right. Well, I don't know, it depends on, if it's a lengthy bond hearing, if it's just a normal bond hearing arguments, we can do it in the morning.
If we can leave it at 2:30, there may be a witness called, so I'd like to leave it at 2:30 if we could.
Okay. Are you entering a denial, I assume?
We are, Judge.
Okay, very good. Anything else?
No, Your Honor.
Thank you very much. Ms. Douglas?
And I got report of fountain in 18 CL 2356. We'll enter denial and ask that it be set with the new law case, which is 23 CF 1226. I think the website shows it's set on 8/14.
I'm sorry, say that again?
We would like to track this case with the new law case. I believe it shows it's set on 8/14 for pretrial.
Okay. We're going to do 8/16.
Yes, sir.
And clerk can get that. Okay, so we'll continue this, enter denial, and come back on pretrial on August 16th at 9 a.m.
Yes, sir. You know, one more thing, Mr. Noakes wanted me to let you know that he's in Walton County and he'll be here as soon as he gets done.
Okay. Thank you very much. Mr. Bell. Yeah. Okay, we'll pass over that. Mr. Flair.
Good morning, Your Honor.
Good morning.
We are ready for Tim Flaherty appearing on behalf of Kyle Chapman. Mr. Chapman is going to be before the court on a motion to reduce bond. Judge, this is State versus Kyle Chapman, case number 23 CF 1015, before the court on a motion to reduce bond. Mr. Chapman was arrested on May 3rd. He is charged under a 5-count information, 3 of which are felonies, 2 of which are misdemeanors. At first appearance, the court set a $1 million bond for Mr. Chapman, $200,000 per count, including the 2 misdemeanors. We're here to ask the court to consider setting a more reasonable bond. As the court is well aware, under Florida Rule of Criminal Procedure 3.131, unless the defendant is charged with a capital offense or one punishable by life and proof of guilt is evident, he is entitled to pretrial release with reasonable conditions. We're asking the court for a finding that the bonds as currently set are not reasonable, and we're hoping to provide enough information to the court to make a finding that it would be proper to impose a total bond of $100,000 cash or professional for the 5 counts. Judge, we're aware that the 2 factors that the court has to consider in such a case under Florida Statute 903-046 are to ensure the defendant's presence in court, as well as to protect the community from any unreasonable danger presented by the defendant. On the first factor, ensuring his appearance in court, I would offer that Mr. Chapman has no prior criminal history, which would also mean no prior failures to appear. Mr. Chapman is currently active duty in the United States Air Force. He has been for 6 years under the current rank of Staff Sergeant. Mr. Chapman's parents, Kim and Greer Chapman, are present in court today, along with several family and friends in the back row here, Judge, and they are available to testify if the court did have any questions. They would also be the people responsible for funding any bond that the court would set. We've also filed several letters of support on behalf of Mr. Chapman to give the court a little bit of insight into Mr. Chapman's character. Those were filed last week with the court. Judge, on the second factor, which is the protection of the community, obviously given the nature of these allegations, that's going to be a concern for anyone involved in a case like this. But I would respectfully remind the court that at this stage of the proceeding, Mr. Chapman is presumed innocent. He's not even had his first pretrial conference yet. No evidence has been introduced. No testimony has been taken. So at this point, I think we all need to look at Mr. Chapman as if he is an innocent person. We do acknowledge that there are conditions that can be imposed that would protect.
Have we reached a probable cause, at least? So
Probable
he hasn't
cause.
done nothing.
I'm sorry?
It's not that there hasn't been some ruling with regards to the evidence, but it's a low standard.
Fair.
Fair.
Yes, Your Honor. To the issue of protection of the community, Judge, I would point out there is a risk protection order that's been in place. That's case number 23MH611. We've also taken the step of having him evaluated for entry into the Veterans Court program. The director, Mr. Rivera, evaluated Mr. Chapman last week and did find that he would be an appropriate candidate. He did put that in writing. We filed that with the court last week. We freely acknowledge that that is by no means a guarantee that he will be allowed entry into the Veterans Court. This is but a first step in that process. However, just by being deemed an appropriate candidate, he does have immediate access to services through the Veterans Court program, which could begin upon his release if he were allowed to be released on bond. Obviously, Judge, there are also other pretrial release conditions that could be imposed to include community control sanctions. He could be ordered to wear a GPS monitor. He could also be ordered to report in person weekly to pretrial services to ensure both his appearance in court and to protect the community. So on those grounds, Judge, we would respectfully ask that the court reduce the currently imposed bond of $1 million to $100,000 cash or professional among the 5 counts.
You said that the court, he's required to have pretrial release. He's required to have a reasonable bond.
Judge,
that's different than a pretrial release, isn't it?
Judge, respectfully, the rule does say pretrial release under certain conditions, but for purposes of that rule, pretrial release can include a monetary amount, but they do use that terminology in the rule.
Is this your case?
Yes, Your Honor, this is my case. Your Honor, the state respectfully requests that the court leave the bond as set. Your Honor, it is accurate that Mr. Chapman does not have any criminal history. However, the facts of this case and the charges that you're charged with are extremely serious. The actions that occurred that day are extremely serious and did in fact place people in danger. He did shoot out the car window of a citizen, and that is what initiated.
I would object to that characterization. That's not been introduced in evidence. That's an allegation.
So it's on the police report that was the basis of the probable cause, was it?
Correct.
Yes, Your Honor.
That she can bring it in. Go ahead.
That initiated this call, which Deputy Hogan and Deputy Carter responded to. When Deputy Hogan and Deputy Carter responded to that, Mr. Chapman was in the middle of the street wearing a bulletproof vest, open carrying a firearm, Your Honor. And that firearm was, according to the police report, pointed at both of these deputies. And if it were not for the actions of the deputies, according to the police report, There could have been serious injuries that day, Your Honor, so the state respectfully requests that the defendant's bond remain the same. I think that it was absolutely a danger to the community, the actions of the defendant this day, and if it weren't for the deputy's actions, more people could have been hurt.
And Your Honor, we're not trying to minimize the seriousness of the allegations at all. These are very serious allegations. He faces a lengthy prison sentence if convicted. We're simply asking the court to make a finding at this stage of the proceeding that there are pretrial release conditions, including the monetary amount, that could be imposed that would accomplish both goals: allow him to be released, but also protect the community and ensure his appearance in court.
Is the state, are there any current pretrial service conditions on there would be conditions of the bond as currently set? In other words, is there a GPS or anything?
I'm unsure of that, Your Honor. I am unsure, I just knew what it was, I just looked and saw what it was set at.
Larry, you can help me out with it if you know.
Your Honor, I'm not aware. I know that it was set at $200,000 per count.
Right, I'm aware.
Yes, sir.
Your Honor, I'm not seeing that. Pretrial services was checked on the first appearance sheet. It looks like it was just set at $200,000 per count.
Based on the severity of the charges, the circumstances that are contained in the probable cause, the court's going to keep the three felony charges at $200,000, and the two misdemeanors will be reduced to $25,000 each. There will be additional condition, though, if he does meet these bonds, then he will be required to have a GPS monitor, and of course there would be no firearms, which there's already risk protection, so that's already taken care of. I don't know if that, I'm going to add that to a condition.
Your Honor, also no contact with the victim.
Yes.
And Your Honor, the other concern is that the bulletproof vest that he was wearing, which is part of one of the offenses he's charged with. I know his guns have been taken pursuant to the risk protection order, but that equipment was part of his military service. I believe he had that vest as part of his military service. I don't know if he would be able to give that to the Okaloosa County Sheriff's Office if it hasn't been taken as part of evidence already. I would request that.
If you're going to ask for it, you got to give me a little information, counsel. I don't know anything about it, and you apparently don't either, as far as what's the current status of it. Is it a military issue? Is it in the...
I think so, Judge. You're right, just due to the fact that he was wearing a bulletproof vest in the commission of a crime, we would ask that he obviously not do that. That's going to initiate another violation if he wears that in conjunction with a crime.
Mr. Flaherty, you got any information on
My understanding, Judge, is that the plates that would have been inside the vest are military issue, but the vest itself, the fabric material, was personally owned by Mr. Chapman. We certainly wouldn't object to an order by the court to forfeit or surrender the vest if it were still in his possession.
It's in his possession, it should be forfeited. At this point, I mean, the resolution of the case, I don't know what'll happen, but just for the condition of the bond. So, anything else?
Just for clarification on the pretrial release condition, is that weekly phone-in, or do you want him to report in person weekly?
State?
Your Honor, the state would absolutely request that he report in person if he's released.
Court will order that as one part of the pretrial conditions.
within 24 hours of his release?
Yes.
Thank you, Your Honor, that's all I have.
Thank you very much.
And Judge, I did e-file an order yesterday, I believe. The court has it, but I also have a paper copy, so whichever the court would prefer.
Well, I assumed that there were some changes to it. Give me you're talking about for today's hearing?
Yes, sir, it's just, it gives space for the court to write, or I can submit an order.
I'm going to let the state or you give me a final order.
Yes, sir. Thank you, Judge, that's all I have.
Thank you very much. Mr. Drell, you ready?
Yes, Your Honor.
Okay, come on.
Thank you, Your Honor.
Sure.
Your Honor, may it please the court, Dustin Durrell, my first client, Mr. Decorius Boone, 22 CF 2539. And Your Honor, we do have a written plea on May 1st.
Yes, sir. Thank you.
And Your Honor, this is just going to be an open plea to the court. We're requesting a sentencing hearing be set with the understanding that the state has agreed to cap any potential sentencing at 12.1 months.
Okay. So, say that again.
Yes, Your Honor. But at this time, Mr. Boone will withdraw his previously entered plea of not guilty and a plea of no contest to counts 1 and 3 through 6, with the understanding that a sentencing hearing will be required, and the state has agreed to cap any potential sentencing at 12.1 months. The state agrees to dismiss count 2, possession of a firearm during commission of a felony.
And just for purposes of clarification, is that 12.1 total? In other words, if there were multiple sentences, they would run concurrent. There's an aggregate of 12.1 or less? I assume that's what it was, but I wanted to
That's correct, Your Honor.
make sure everybody understands that.
And just so the court's aware, one of the possession of a firearm by delinquents being dismissed, and that will bring his score below 44 points, and that is part of the reason for the 12.1 cap, Your Honor. State is going to request a pre-sentence investigation on this case.
Okay. So, let me go ahead and inquire just a little bit of Mr. Boone, just to make sure he understands what's going on. Mr. Boone, would you raise your right hand? Do you swear or affirm that the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
Okay. So, Mr. Boone, you can put your hand down. I just need to ask you a few questions, and there's 2 reasons why I'm asking you these questions. One, I want to make sure you understand what's going on, okay?
Yes, sir.
And I want to make sure that you're entering into this plea agreement freely and voluntarily. Those are the 2 things. That's the reason why I'm doing it. You understand that?
Yes, sir. I went over that.
Okay, so that is my first question. I see you signed the plea agreement, and first of all, have you read it closely?
Yes, sir. I went over it.
And you've gone over it in detail with your attorney?
Yes, sir.
And you understand that by entering this plea agreement here today, it's a final resolution, kind of the first part of the case.
Yes, sir.
You've got a cap on the sentence, but we're not going to sentencing, and the sentencing is not part of this other than that there's a cap on it, okay? The rest of it's going to go to another hearing, and you're going to get a chance to have your attorney argue on your behalf, and the state's going to argue, they'll probably argue for the full 12.1. Do you understand all that?
Yes, sir.
Okay. You understand that by entering in this plea agreement, though, you're basically the first part, the adjudication of this will be a withhold?
We're going to leave that to the discretion of the court, Your Honor.
Okay.
That'll be determined at the sentencing hearing.
Very good. So whether or not it's a withhold or an adjudication, and then the sentencing would be a part of the next hearing. Do you understand that?
Yes, sir.
But you can't back off of this part of the agreement if you're not happy with what happens at that next hearing. Do you understand that?
Yes, sir.
Okay. And you're doing this freely and voluntarily?
Yes, sir.
Okay. Based upon that, the court will accept your plea agreement. Do we have a sentencing score sheet?
I do, Your Honor. It is handwritten, and I will have to make a quick change to it. I was going to provide it at the sentencing hearing,
That's fine,
And we're
as long as we're on the record that it's not a downward departure, that this is,
It would not be a downward departure, Your Honor.
okay, very good. So the court will accept the plea agreement, as written, and on 22 CF 2539, counts 1, 3, and 7, as charged. You're going to enter a no contest plea, and there'll be a sentencing hearing with a cumulative cap of 12.1 months, and the state will dismiss count 2. That's the felony possession of a firearm count. Okay?
Thank you.
Anything else?
No, Mr. Boone, Your Honor.
Thank you, Mr.
Do we know when the sentencing will be?
Yes, PSI is being ordered, so let's,
There's an August 17th, 2:30. With permission of time for PSI.
that sounds good. August 17th, that's sufficient? Okay. And we'll do it at 2:30.
Thank you, Your Honor.
Thank you very much.
Your Honor, next I have Ms. Kenesha Austin. The state extended an offer to Ms. Austin. I was speaking to her about it. She requested a counter. I brought that to Ms. Sharpless this morning. She has agreed to the counter. I need to go back to Ms. Austin, let her know we're good, make sure she's still good with what she requested. And I do anticipate a plea next cycle, though, Your Honor, if we may have a continuance.
Do we need to go all the way to the next cycle? Or do you
Whatever the next available date is would be fine, Your
Yeah,
Honor.
we can do it for a plea. July 18th is in the morning, is still not too heavy. It's good. So why don't we come back July 18th in the morning?
July 18th? Yes, Your Honor.
We'll continue to July 18th.
Thank you. And finally, Your Honor, Mr. Chad Crane, this was a PTI. Mr. Crane had a couple of questions. I was able to clarify that with Ms. Sharpless this morning. I will get a revised PTI to Mr. Crane and hopefully have that submitted to the court soon and drop him off. We can leave him set for the 18th as a control as well, if you'd like, but I anticipate filing the PTI shortly.
Okay. Yeah, we do need to set, why don't we just set it for our standard, our pretrial 8/14.
Yes, Your Honor.
But like I say, it'll come off, but that's our standard. 9 a.m.
And I believe that's all I have today, if I may be
Thanks,
excused.
Mr. Gurley. Have a
Thank you,
nice
Your Honor.
day. Mr. Ballard?
Jim Ballard, appearing for Josh Alexander in case number 22 CF 2299. I have a signed sentencing recommendation. I have Sergio Perez Cairo's here. We went over it with Madame Translator downstairs. As soon as she finishes up.
Do you have an extra copy?
No, Your Honor, I don't.
Okay. So go ahead. So you're announcing a plea here today? Is that it? Would you announce the terms of the plea?
Your Honor, the terms are a plea of no contest to counts 1 through 4, to an agreement with the state of an adjudication, a withhold adjudication, 2 years probation that would be concurrent with his Washington County sentence, $515 in court costs. He will maintain gainful employment or 2 job applications per week. He will do 50 hours of community service. He will not have any drugs or firearms while under supervision, and he will submit to random urinalysis at least once a month.
And Your Honor, I do have this worksheet.
Okay. Would you bring me the plea? I need the plea. Is the defense okay with this worksheet?
Yeah, Miss Emily gave me a copy yesterday.
Would you bring me the plea? Sharpless, you might want to sign.
Sign this.
And are all four of these charges felonies?
They
Yeah,
are,
two-
Your Honor, yes.
2 are second, 2 are thirds.
Your Honor, it isn't speaking. Before you do your vote, we're going to have Teresa come and her client's a collector.
Okay. Why we're waiting for the interpreter, and so as soon as she gets here, we'll bring him back up. So if you'll just hang with us just a little bit. So, thank you. Okay, you want to just start? Tomorrow, you're next up on my list.
Sure,
Robert
Mayor.
Hall.
I can call a few out of custody. I think Mr. Hall is probably in custody.
He is.
Yes, he is in custody.
But we can call
You
Dr.
want
Howard.
to do the out of custody first?
The first one I'll call is Ms. Marilyn Bohannon, Your Honor.
Hold on a second.
That's 18 CF 1079. We're asking this matter to be continued, Your Honor. This has been passed for compliance. Ms. Bohannon made a good faith payment this morning. It's my understanding she has approximately $700 left. She's told me that if she was given until a date in August, she would be able to reach full compliance. I don't know if the state or the court would be willing to push us until an August date for this case. The reason for the request is the state's made an offer to revoke and terminate this probation, but she was given the benefit of a withhold of adjudication on the front end, so we're trying to avoid that adjudication, Your Honor.
Your Honor, this is a situation where it's financials only, so the state would be willing to give her a little more time. I do not want to pass this past August, but I'd be okay with giving her one more continuance to gain compliance so that the VOP can be withdrawn instead
If
of
we
her.
continue this to August 17th? Good, ma'am? We'll continue this to August 17th, and that'll be in the morning at 9 a.m.
Thank you, Your Honor.
Good luck.
We're going to interrupt you just a moment because the interpreter, she has to be back.
Sure.
Thank you.
Please, thank you.
Is he your name?
Teresa Iribarren.
Do you agree to accurately translate from English to Spanish and from Spanish to English matters brought before the court, so help you God?
I do.
Okay. You kind of threw this off, you're supposed to announce. You announce without him being able to understand it. So everything that we did prior to announcing that you needed an interpreter is of no value, because he didn't hear anything. We're here because of him, not because of you and I and the state. So, yeah. So I need you to explain again the terms of the plea agreement so that he can hear you. You can go slowly so that the interpreter can.
Your Honor, Jim Ballack here, representing Sergio Perez Cairo for case number 22 CF 2299. Mr. Perez Cairo is going to plead no contest to all 4 counts from the information. And he's agreed to sentencing with the state, where he'll accept an adjudication of guilt, or a withhold of adjudication. He will be placed on probation for 2 years, concurrent with his Washington County probation. He will pay $515 in court costs, He will do 50 hours of community service. He will either maintain gainful employment or submit 2 job applications per week. He will not do drugs or possess firearms during his supervision, and he will submit random urinalysis at least once a month while on probation.
So, a couple of points of clarification. One, where is the supervision for his probation going to be conducted? Here or in Washington County?
Your Honor, I don't know the county of his residence, but I think it will occur in that
Where does he
county.
live, Mr. Ball? Miami? Okay. Okay.
So, well, like, the supervision will likely be transferred to Miami-Dade County.
Okay, so it won't. So what is the Washington County case? Do we have a case number? I'm a little,
Yes, Your Honor, I can do that for you.
it needs to go into the plea agreement because we're running concurrent with that. We want to be clear what that is.
Your Honor, I believe the Washington County case number is 6722 CF 289.
Good. Can I have the plea agreement? And do we have a score sheet?
Yes, I think
You handed me the score sheet over?
I believe so, Judge.
Did I review the score sheet? Okay, got it. So, Mr. Perez, I need to swear you in. Would you please raise your right hand? Do you swear or affirm that the information you're about to provide this court is the truth, nothing but the truth, so help you God?
I swear, Your Honor.
So, Mr. Perez, the purpose of my questions here today are twofold. One, I want to make sure you understand what the terms of this plea agreement is. And secondly, I want to make sure you're entering into this freely and voluntarily. Okay?
Yes, sir.
So, you heard your attorney state the terms of your plea agreement. And I see that those terms are also contained in the what's called a sentence recommendation, which is really a plea agreement form that you have signed. And my first question to you is, have you read this? I know it's in English. Can you read English? No.
No puedo leer en inglés, pero sí me lo explicaron usted mismo, señor.
I cannot read English, Your Honor, but the terms were explained to me in Spanish.
Okay. And so you feel like you have a good understanding of this plea agreement?
Sí, señor.
Yes, sir.
And you understand that by entering into this plea agreement, you're waiving some valuable legal rights, the most important of which is the right to go to a trial to force the state to prove their case beyond every reasonable doubt. You're waiving that in order to have a final resolution of this case here today.
Sí, señor.
Yes, sir.
And so there'll be a withhold of adjudication for each of the 4 counts. You'll receive 24 months probation, and this will run concurrent with the probation in Washington County. I don't see the case number. I thought you put the case number on here. Did you put the case number on here?
We announced
So when you had this plea agreement explained to you, were you able to have all of your legal questions answered regarding this plea agreement?
Sí, señor.
Yes, sir.
Do you have any further questions regarding this plea agreement?
No, señor.
No, sir.
And you are entering into this freely and voluntarily?
Sí, señor.
Yes, sir.
Nobody's coercing you, threatening you to get you to enter into this plea?
No, señor.
No, sir.
Does this have any potential impact on immigration status? And either of the lawyers? Counsel, do you have any potential, does this have a potential immigration status? Impact on his immigration status? I don't know what his immigration status is.
I think anytime you enter into a plea, we're hoping that since it's a withhold, he understands the risk he's taking.
I am I'm a legal resident of the United States, Your Honor. I've been living here for 11 years.
So what I want to make sure is that you have had it explained to you by your lawyer or somebody, or you understand that the entry of this plea could have an effect on your immigration status. I don't know if it will, but I want to warn you that it might be. I don't want you to well, I didn't realize it would impact my immigration status. I thought I would be fine with it. You understand? Again, nobody's trying to trick you here. Nobody's trying to pull something over on you. We want to make sure you understand what you're doing here. So you can follow this probation. Because if you don't follow this probation, you're going to be brought back and subjected to incarceration, which is not what we want. But you need to understand what you're doing. So let me ask you again. Has it been explained to you that there may be a potential impact on immigration status based on this plea?
Sí, señor.
Okay.
Yes, sir.
Okay, do you have any other questions regarding this plea?
No, señor.
No, sir.
Very good. Based upon that, the court will accept your plea agreement. There'll be a withhold of adjudication on all counts, and the defendant will be sentenced to 24 months probation on each count. They'll run concurrent, they'll run at the same time, and it'll also be concurrent with case number 6722 CF 289 out of Washington County. You also must maintain employment and, of course, have no firearms, drugs, or illegal drugs. You have to do certain fees, no trespass, and a monthly UA. Okay? Any questions?
No, señor.
No, sir.
Okay, thank you very much. Anything else?
We just appreciate you allowing me to come as well.
Thank you. We've got some folks we want to do without attorneys. Why don't we do those? And then
Representative.
Get is Stephen Arnett here? Mr. Arnett, would you come forward, state? Would you announce?
Yes, Your Honor. This is the state of Florida versus Stephen Arnett. That case number is 22 CF 1103, Your Honor. He's here for a violation. The state's offer is revoke and terminate, send the financials to a lien, and the VOP cost of $100.
So, Mr. Arnett, the state's making you an offer here today. You do have a right to have an attorney appointed to make sure you understand exactly what any agreement you might enter into or to contest this. My first question to you is, you wish to have an attorney appointed?
No, sir. No,
You
sir.
want,
I can represent myself, sir.
okay. So are you wanting to take the state's plea agreement, or are you wanting to deny and contest this?
Can you explain it to me a little bit more? I didn't really hear her.
Okay. Why don't you go slow and explain it again.
So, Your Honor, Mr. Arnett would admit the violation.
And the violation is primarily financial?
It is, failure to pay court cost, failure to pay cost of supervision. There was some outpatient treatment and some community service hours that were not completed. But again, the state is, if he admits a violation, he would be adjudicated guilty.
Has he already been adjudicated guilty previously?
Just one count, possession, paraphernalia, and withhold possession.
Okay, so it's withhold, so you get an adjudication of guilt. You'd be guilty, you'd be adjudicated as a felon. That's number one. That's not an insignificant, which you're prepared to be aware of.
Your Honor, I think these were both misdemeanors.
They were.
I don't think one of these were a felon. I don't think.
Both of them were dropped to
Okay,
misdemeanors.
good.
Um,
So they're both withhold?
One is guilty of possession,
Okay,
paraphernalia.
so you've already been deemed guilty on the one that's when you did it.
and Your Honor, I did forget to mention, because one of the counts was possession of marijuana, the adjudication, I do believe does come with a driver's license suspension.
It did.
But if you, but I don't object to the court, stating that if you're eligible, you can get a hardship license.
The judge before already told me that I was able to get my hardship license.
So what's the deal? What's the plea?
Yeah, so Your Honor, he would admit the violation, he would be adjudicated guilty of both of these counts, his probation would be revoked and terminated, and any financials he still owes would go to a lien against him. Again, I don't object to him having 180 days to pay that before it goes to a judgment as well.
Did you understand it, all that?
Yes, sir.
Okay. Do you wish to, how do you want to proceed? You want to accept that plea deal?
Yes, sir.
Okay. You good with that?
Yes, sir.
Okay. Let me just ask you a couple of questions. You raise your right hand. Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
So you heard the state give you the terms. Have you written this thing up, Mr. Shelton?
No, Your Honor, but I
You have to give me a written plea agreement. I appreciate you trying to get these things pled, offering them, and it's very efficient, but we do need to get some of this in writing. You want to hang around, you can.
Yes, sir. If you can hang around, I will do that.
Okay. Why don't we do that, and then I'll make sure that, you've read that and you understand what the terms are. Just hang with us a little bit. Caitlin Burnett. Did the state announce on this case?
Yes, Your Honor. Ms. Burnett's case is 22 CF 2281, Your Honor. This is a violation for failing to complete outpatient treatment. The state's offer at this time is to continue her withhold of adjudication, modify her probation to include 6 months of drug offender probation followed by 2 years of regular probation. And then she would complete the original requirements of her probation, Your Honor, and the $100 violation of probation fee would be assessed. I also do not have this written, so if she wants to take it today, then I will write that up.
Man, what do you think? You have a right, first of all, you have a right to have an attorney appointed so that you can have legal representation in order to interface with the state to make sure that, one, you understand what you're doing. And this is important. What they're suggesting is you continue on probation. You need to understand. They're basically giving you some more time.
Yeah.
They're making a little higher level of supervision. If you're walking down the road, if this happens again, they're going to be seeking incarceration. So you need to understand what you're agreeing to, and in your own heart whether you can do it.
Yeah.
But it doesn't do any good to Oh, we got a good agreement here.
I can, Your Honor. I've done everything that my probation has all asked except these classes. And the only reason that classes haven't got done is because of Bridgeway.
Because of what?
Because they say that I missed 3 times and I'm voting
Okay.
schedule with them.
Here's what we need to do. I need to appoint you an attorney so you can talk to your attorney about that. Because it sounds to me that you're raising some legitimate issues about whether or not this probation will give them an opportunity to, talk to the state and whatnot. So, you want to have an attorney appointed?
Does that mean I'll be incarcerated?
No, ma'am. You're
Okay.
not going to get incarcerated.
As long as
Okay,
I'm
you're not getting
appointed.
incarcerated at all today.
Okay.
Today is like plea day. You're entering a denial. I'm gonna enter a denial on your behalf, which preserves all of your rights. You're saying, I didn't do that.
Right.
And I'm appointing you an attorney so you can talk to them,
Okay.
okay? And figure out what's going on.
Okay.
You know, was there a real violation or what's going on? So I'm gonna appoint the public defender.
Can she fill out the one-page application?
Yes, you do have to fill out, but she's probably this is a violation of probation. Did you have a public defender last time?
Yes.
They do require an application
Okay.
for a view.
That's fine, that's fine.
Is it a text
Your Honor,
violation or is there a new law?
honestly, I don't need an attorney, and I understand my probation officer
Steve,
has
we'll be
explained
right.
this to me thoroughly, and I agree on everything that the state is offering me. I'm okay with doing more time of probation because I still have 2 years of regular probation to complete.
Okay. So raise your right hand for me. Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, Your Honor.
Okay, so you heard the state, apparently you've been talking with probation and they explained to you the terms of the offer that the
Yes,
state
Your
would
Honor.
make? So drug offender probation, you understand what that means?
Yes, Your Honor.
And you've got to obviously continue, the most important thing is to continue the drug treatment.
Yes, Your Honor.
Okay, you're willing to do that?
Yes, Your Honor.
Okay. You believe this is in your best interest to enter into this plea here today?
Yes, Your Honor.
You're waiving the right to contest it? You don't even want an attorney appointed? You believe this is a better way to resolve this matter here today?
Yes, Your Honor.
Nobody's threatening or coerce you to get you to enter into it?
No, Your Honor.
Okay. So what we do need to get a plea form. So if you can hang around just a little bit, and we'll get that before you leave today, okay? Dakota Kensinger.
Inmate, Your Honor.
That's right, sorry. Castro's, Yondry.
I got Dakota Kessinger approaching.
Okay. Kensinger. Did the state announce this?
Yes, Your Honor, one moment. This is Dakota Kessinger, case number 23 CF 765. He's also here on 2 VOPs, 22 CF 1946 and 22 CF 1324. The offer is 25 years as a midman and a $500,000 fine. This is
okay. We're not going to bleed that out today. So, Mr. Kensinger, you have a right to an attorney in this.
Yeah, can
You
you
wish to
appoint
have
me?
an attorney appointed?
Yeah, can you appoint me
The
one?
court will appoint the public defender. The court is going to issue, is going to enter a denial on your part, so that you have a chance to meet with your attorney, figure out where you're going. Obviously, based on the offer here, it's a very serious matter. You need legal representation.
Yes, Your Honor. If we can have Mr. Kessinger make sure to fill that application out, please.
Okay, that'd be great, and we'll come back, okay. Why don't we'll track it with the new case, we'll track all this to 8/16 to our regular pretrial, would that work?
Yes, sir. And the reason Mr. Kessinger needs to fill the application is he's stated multiple times on the record he intended to hire private counsel. So I want to make sure that we qualify on his cases.
Okay. Okay,
All right.
you understand that?
Yeah, when I go back to court?
August 16th.
August 16th, but in the meantime, you'll meet with your
All
attorney.
right,
Thank you. Okay. Is Yon
Esteban Castro here? Castro. State?
Your Honor, I am slightly confused as to why this individual is on the docket. Ms. Goodman represented him, and he came to a hearing last week. I believe we settled all of his matters in a written plea agreement, so I'm just confused why he's back on the docket.
Okay. Let's just confirm that, and we'll pull it up.
Yes, Your Honor. I do recall that she did not enter an appearance, but she was at court that day to enter the plea, which caused some confusion.
The defendant did plea on
I'm sorry?
The defendant did plea on June 14th, so it should not be on the docket today.
Okay, very good. Dane Solomon, inmate?
Dane Solomon,
I didn't mean to cut you off, but when we have those serious plea offer like that we shouldn't, it needs to be with representation.
I understand, Your Honor.
So, Mr. Solomon, why don't the state go ahead and announce the case?
This is Mr. Dane Solomon, case number 21CF000499. He is here charged with a violation of probation, and the offer is a guideline offer of 27.5 months DOC. Or sorry, 37.5 months DOC.
So, Mr. Solomon, you do have a right with these new violation of probation charges to have an attorney appointed. Do you wish to have an attorney appointed?
I do, Your Honor.
Okay. Court will appoint the public defender. Court's going to issue a denial on your behalf. And when do we want to come back?
Your Honor, if we can set Mr. Solomon for August,
Okay.
based upon some of the pretrial paperwork, I probably will look at getting Mr. Solomon evaluated.
August 17th?
Yes, Your Honor.
Very good. We'll come back August 17th in the morning.
Thank you, Your Honor.
All right. And that's all the folks that I have that do not have attorneys. So, who wants to go with some, the three PDs?
I have a few out of custody that I
Okay,
can.
why don't we go ahead and do those, and then maybe we'll take a short break here this
Your
morning.
Honor, before we take the break, I do have one out of custody I'd like to take. It's a short bond hearing.
Sure.
The first one I'll call, Your Honor, is Miss Renee Hendricks. Ryan Morrow, Miss Hendricks. Your Honor, we're asking the court to give us continuance to the July date. I've spoken to the state on this. It's my understanding she's provided a prescription to probation for the substance that was alleged in the affidavit, and everything else she is now reaching towards compliance, and the state just needs to confirm all that. So we're asking for the July date for that to get done.
So why don't we come back July 18th in the morning? Continues to July 18th at 9 a.m. Okay? Thank you.
Do you want me to go ahead and call some more out of custody folks, Your Honor? The one that I do have in the gallery is actually set for the afternoon, but me and Mr. Bosco would like to address it this morning, if that would be okay. And I can hold him till the end if that would be better.
Is it, what is it, a plea? Or what,
Your Honor, I'm sorry?
what type of action is it?
It's current.
The afternoon stuff tends to be longer. I just want to make sure we're not.
What we're gonna do right now will not be, Your Honor. We're trying to move it off your docket.
Okay. If you want to call them, that's fine.
The case is Dawn Frazier, Your Honor. It's set for contested hearing this afternoon. I've spoken to Mr. Wasco on this. This is a case that we're trying to get him towards compliance. Come on up, Mr. Frazier, I'm sorry. He is currently in treatment for the substance use evaluation treatment component. It's my understanding he has another 7 weeks of treatment left to do. He's also asked me to inquire with the court if the court would allow him to perform community service work in the meantime to finish out the financials that remain. And those are the two requests from the defense today, Your Honor, is one, in order from the court allowing him to perform community service work to finish out the financial components, And two, we're asking for this matter to be passed to July to allow him to move towards compliance with the treatment component of his probation, Your Honor.
That's correct, Your Honor. The state is ready to proceed on our evidentiary hearing this afternoon. I've sent out my subpoenas and I'm ready to go. However, Mr. Marr has made representations to me that this is a defendant who's working hard to do what was expected of him in the first place and trying to get into compliance. I'm taking him at his word here, and I would be completely fine continuing this. That way we can resolve this matter.
So when do you want to continue it to?
Your Honor, I know Mr. Marr said, sorry.
He just said 7 weeks, and then he asked for July, which is only 4 weeks. Should we do it in August? I'm not suggesting that. In July, if we need to kind of just check in, that.
I think that July would probably be better for a status, and the reason I say that is just to check in and make sure that this defendant is continuing to comply.
Very good. So we'll continue this to July 15th at 9 a.m. That'll be a status. That won't be an evidentiary hearing.
Thank you, Your Honor. Would the court be willing to enter a order on...
Any objection with regards to the other requests? I don't even know if we're able to do that. That's community service for
fines and costs, Your Honor.
No objection, Your Honor. I think they worked it off at $11 an hour, I believe.
Court's okay with that.
Great. Thank you, Your Honor.
Thank you.
Your Honor, I think that may be all I have right now. I may have some in-custody folks, but I'll need a moment for some paperwork.
Mr. Gates? Yes, Your Honor, if I can take Mr. Norman Halfacre, Your Honor. Mr. Halfacre is before the court in 23 CF 495.
Go ahead, Mr. Gates.
Yes, Your Honor. Mr. Halfacre is here on a bond modification request, Your Honor. Essentially, Mr. Halfacre has been released on bond, and over the course of his release, he's been complying with various components of that pretrial release bond. There was a GPS issue as well as essentially house arrest, both conditions. The state, after review, was willing to modify. Unfortunately, it came down to the scram monitor, and we were unable to reach an agreement with that with the state. So we've set the hearing before the court. Mr. Halfacre has complied with all the conditions of the bond as set forth at first appearance.
When was first appearance? Was that 27th of February?
Yes, Your Honor, it was.
Okay.
Since then, he's, as I said, he's followed all conditions of the pretrial release. He's met with his pretrial services officers. I've spoke with him on a couple different occasions. He's had no violations. He's stayed in touch. He's been the model pretrial releasee. We're simply asking the court to remove the screen monitor. It's becoming a burden, financial burden for Mr. Halfacre.
How much? What's
Roughly, it is $300 per week. About $1,000 he's been out since he's had it on per month. $300 per month. $300 per month, Your Honor.
It's a little different.
I understand. Yes, it is, Your Honor. And I've had this conversation with Court Alternative Services in Milton, and we've tried lowering that to $1 a day like we do the GPS. Unfortunately, because they're a private organization, they will not lower that cost. It's, as I said, a point when Mr. Halfacre is having financial issues completing the scram monitor. He is up to date on that as of today to be safe. I did reach out to pretrial services.
What's the status of the underlying case?
We are working through depositions. In fact, Mr. Halfacre is on my list of cases to schedule depositions, hopefully before the August 14th pretrial date. I do have some gaps in my availability in July, but I'm trying to get those scheduled as soon as I can. Speaking with pretrial services, Your Honor, there are other alternatives. We could do weekly UAs. They said that wouldn't be an issue as long as Mr. Halfacre was compliant.
So basically you're asking to delete the scram requirement?
Yes, Your Honor. We prefer to be deleted completely. As I told Mr. Halfacre, if the court didn't feel comfortable, I had a couple of suggestions that would be alternatives that would save him a little bit of money in the long run. and still potentially could give the court a little bit of assurance on his compliance.
If you want to throw those out there on.
Yes, Your Honor.
I'm sure what the state's going to say.
There's the weekly ways of pretrial services. They said as long as Mr. Halfaker is compliant, that would be something we could do. Mr. Halfaker mentioned this morning that Court Alternatives actually has a portable breathalyzer too. That is an alternative that we potentially could have for Mr. Halfaker that would be at a reduced cost as well. Those are just a couple that I could think of right now. If the court wants, I can have Mr. Halfaker explain it because he was asking about alternatives during the last meeting with them.
Good morning, Your Honor. I was informed by the company that handles the scram monitor that there is a portable breathalyzer option. I'm not familiar with the technology, but it was shared with me that device is cheaper. Of course, Your Honor, I would appreciate and like to have the device removed completely. But also keeping an open mind to any other options that are available. And would just also like to respectfully say that Mr. Gates has done a tremendous job, and also that I appreciate the state being flexible up to this point as well too. And I think I'm being treated fairly.
Your Honor, I reviewed the motion, and it seems that there are 2 points to it. First, the defendant is sorry for having done his 4th DUI. Right, and in addition to that, it's gotten too costly for him. My position is that your 4th DUI should not be cheap. What's cheap is an Uber ride, right? This is the 4th DUI. He does not have my sympathies for how expensive this process has gotten for him, to be frank. Your Honor, I believe that scram monitor is needed here. I think he needs to have 24-hour monitoring to make sure that he's not drinking while he's on bond or on pretrial release conditions. Regarding the portable breath test monitor, the state has no objection to that. If it's cheaper for him, that might be a good option. But he needs to know that he's going to be having to carry around a device that's about the size of an iPad mini and blowing into it randomly at all hours of the night. That is not a convenient task.
So you're familiar with the portable device that I'm not? So.
Yes, Your Honor. I apologize, I didn't mean to cut you off. I am familiar with the device. I had a realtor who used that device when I was a misdemeanor. She was not able to have a scram monitor on because of her work, so she needed to carry around the portable device, and it worked well for her. The way the device works is it will shine randomly throughout the day. And he has a set amount of time to pull out a straw and blow into a device about the size, as I said, of a iPad mini. He has to hold it at a certain angle, and it will take a photo of him blowing into the device. That way you know that it is in fact this individual and not someone else.
You aware of all this?
Yes, Your Honor.
Explain to you.
Yes, Your Honor.
How much does this cost? How much does this?
I was just informed that it was cheaper, Your Honor, so every dollar at this point would be helpful.
And Your Honor, Mr. Halfaker did want to let the court know that that would not be an issue for him. He is self-employed and works out of the house, so having that on that device around if the court is inclined to do it.
The state's not opposed to that?
I'm not opposed to that. I think that that would be a good resolution if money is the primary concern, but I'm not willing to go completely no monitor because I do think that when you get to your 4th DUI, you need something there to keep you from drinking.
I totally agree. I mean, if you hadn't offered this alternative, I would not have granted your request to remove the scram.
Yes, Your Honor.
And I mean, you're on pretrial release. You haven't even, this matter is not even been resolved. It's not uncommon for lengthy probation periods. Again, I have no idea where y'all are headed as far as resolution, if that's even possible. But it's not uncommon to mandate a scram device for years. This is fourth DUI is a very serious
issue. I appreciate the fact that, you know, if you got religion after all that, and I know this is a difficult situation. I understand. I've said many times before, if alcohol hadn't been legal for 10,000 years, virtually entire civilization history, it'd be illegal today. But this is every bit as destructive as virtually any illegal drug we have in our society, and way more common. So I mean, I get it, but that doesn't, that doesn't take away from the necessity, the court's position that at this point we have to look at the safety of the community as to trump the inconvenience or even monetary burden it places. So, if the state's okay with the alternative, I'm okay with it.
Yes, sir. I will follow up with an order, and then have Mr. Losco review it before I send it over. Thank you, Your Honor. Thank you, Your Honor. Mr., just for the court, Mr. Affaker is scheduled for August the 14th pre-trial already.
Okay, very good.
Thank you, Your Honor.
No, so technically, the bond motion is denied as requested, but the alternative, it would be modified. So it's granted, but the modification would not be as requested. The modification would be, what is it called?
The portable ground testing.
Whatever.
I will try to get my best to get that identified, and I will make sure the order specifies that he needs to stay on the scram until they can replace it with a portable breathalyzer test.
Okay. So it technically was. Did I grant it or not? Did you?
I would say the court granted the modification, and we will follow up with an order until that order is signed and the breathalyzer is given to him. He'll be on the scram then.
Okay, very good. Thank you.
Thank you.
Thank you, Madam Clerk.
Judge, let me address one.
Sure. Then maybe we'll take a short break here after that.
I've got number 16 on the docket, Sean Coy. This will be quick. He's before the court on 22 CF 32 and 22 CF 161. He's actually in federal custody. The felony battery case, 22 CF 161, I think the state needs to confirm a possible resolution on that case with the victim in compliance with Marcy's law. And I believe the state is amenable to, or is requesting a continuance, and I have no objection, Judge.
So he's in federal custody currently?
Yes,
The
sir.
defendant is, Your Honor. Yes.
I'm sorry?
The defendant is in federal custody, and he will be there for quite a number of years.
So what do we need to do for today?
Just to continue to you want August, or is that enough time?
Yeah, let's do August, Your Honor. I can explain more if we approach the bench, but the victim is in a treatment facility. So
We don't need to really go into that.
They're in a treatment
We'll continue to August
facility.
22nd. Y'all are trying to determine a resolution,
Yes,
and it's not particularly pressing because he's incarcerated.
Yes, sir.
Okay.
August of what, Your Honor?
22nd at 9 a.m.
Thank you, Judge. That's all I
Tomorrow,
have
do you
today.
have
I have
one before
one
we
prior
take a break?
policy I thought that we could call for.
Okay.
Your Honor.
Let's do it.
This is Mr. Bobby Davenport. This is 20 CF 2964. Your Honor, the state.
Hold on.
Yes, Your Honor.
What's the last name?
Davenport.
Davenport?
Yes, sir.
Go ahead.
The state has recommended Keaton and Phoenix House as a possible resolution for this case. I haven't had an opportunity to discuss that in depth with Mr. Davenport. We're not anticipating a contested hearing in this matter. We are expecting to resolve this via negotiated plea, though I don't anticipate it will be via those programs, but we're going to talk about it. I'm asking the court to allow us to pass this to 7/18. I'm going to talk with the state probation about something that maybe he can accept. It mostly boils down to issues with work. Your Honor, he's trying to keep his job.
So we've kind of laid everything out. July 18th, we either have a resolution or let's set it for hearing.
Understood, Your Honor.
Yes, sir.
Okay, we got, got to kind of have an end date for it.
Understood.
So we'll come back July 18th at 9 a.m. And if the clerk would just make note in your minutes that the last continuance will either be a plea or we'll go to a hearing, or schedule it at that time, conduct it at that time.
Understood.
Schedule it at that time.
Thank you.
Thank you. Okay, let's go ahead and take a morning break. We'll break for about maybe 10 or 15 minutes, and we'll come back and finish up the morning doc.
All rise, please.
Buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
Congratulations, Dixie Dan Powell, for your recent induction into the National Trial Lawyers Top 100. The National Trial Lawyers Top 100 is an organization celebrating premier trial lawyers from across the country who meet stringent qualifications as civil and/or criminal defense lawyers.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
For more than 70 years, the sweet aroma of the Crestview's Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045. Dave's Tire Pros makes buying tires simpler. They offer a straightforward approach to tire and auto service that includes nationwide warranties, a hassle-free experience, and a great selection of Michelin tires. No matter what you drive or where you have driven, Michelin has a tire to fit any need. Visit our store in Crestview or online at Dave'sTirePros.com. Tire Pros love the drive.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
At Powell, Powell & Powell, we are a family of lawyers working together as a team for our clients. For more information, visit us online today at www.powellpowell.com. powelllawfirm.com.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office on North Verdon Boulevard for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestviewagent.com.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hi, I'm Amanda Gaskin with Briarpatch Realty. Helping qualifying heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Fat Boy's Juicy Beef and Tasty Bird is located at 482 North Wilston Street in historic downtown Crestview, just 1 block from the courthouse. We open at 10 a.m. with amazing lunch specials until 2 p.m., serving incredible burgers, wings, sandwiches, and appetizers. Join us for happy hour Monday through Friday from 3 p.m. to 6 p.m. Hope to see you soon.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
Congratulations, Dixie Dan Powell, for your recent induction into the National Trial Lawyers Top 100. The National Trial Lawyers Top 100 is an organization celebrating premier trial lawyers from across the country who meet stringent qualifications as civil and/or criminal defense lawyers.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
For more than 70 years, the sweet aroma of the Crestview's Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045. Dave's Tire Pros makes buying tires simpler. They offer a straightforward approach to tire and auto service that includes nationwide warranties, a hassle-free experience, and a great selection of Michelin tires. No matter what you drive or where you have driven, Michelin has a tire to fit any need. Visit our store in Crestview or online at davestirepros.com. Tire Pros love the drive.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
At Powell, Powell & Powell, we are a family of lawyers working together as a team for our clients. For more information, visit us online today at www.powelllawfirm.com.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office on North Verdon Boulevard for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestviewagent.com.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hi, I'm Amanda Gaskin with Briarpatch Realty. Helping qualifying heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Bad Boy's Juicy Beef and Tasty Bird is located at 482 North Wilston Street in historic downtown Crestview, just 1 block from the courthouse. We open at 10 a.m. with amazing lunch specials until 2 p.m., serving incredible burgers, wings, sandwiches, and appetizers. Join us for happy hour Monday through Friday from 3 p.m. to 6 p.m. Hope to see you soon.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and that's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
Congratulations, Dixie Dan Powell, for your recent induction into the National Trial Lawyers Top 100. The National Trial Lawyers Top 100 is an organization celebrating premier trial lawyers from across the country who meet stringent qualifications as civil and/or criminal defense lawyers.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045. Days Tire Pros makes buying tires simpler. They offer a straightforward approach to tire and auto service that includes nationwide warranties, a hassle-free experience, and a great selection of Michelin tires. No matter what you drive or where you have driven, Michelin has a tire to fit any need. Visit our store in Crestview or online at daystirepros.com. Tire Pros love the drive.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
At Powell, Powell & Powell, we are a family of lawyers working together as a team for our clients. For more information, visit us online today at www.powelllawfirm.com.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office on North Verdon Boulevard for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestview.agent.com.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hi, I'm Amanda Gaskin with Prech Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Bad Boy's Juicy Beef and Tasty Bird is located at 482 North Wilston Street in historic downtown Crestview, just 1 block from the courthouse. We open at 10 a.m. with amazing lunch specials until 2 p.m., serving incredible burgers, wings, sandwiches, and appetizers. Join us for happy hour Monday through Friday from 3 p.m. to 6 p.m. Hope to see you soon.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and that's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
Congratulations, Dixie Dan Powell, for your recent induction into the National Trial Lawyers Top 100. The National Trial Lawyers Top 100 is an organization celebrating premier trial lawyers from across the country who meet stringent qualifications as civil and/or criminal defense lawyers.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045. Days Tire Pros makes buying tires simpler. They offer a straightforward approach to tire and auto service that includes nationwide warranties, a hassle-free experience, and a great selection of Michelin tires. No matter what you drive or where you have driven, Michelin has a tire to fit any need. Visit our store in Crestview or online at daystirepros.com. Tire Pros love the drive.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
Hey, DJ, the sheriff's office doesn't actually show an active warrant for Mr. Finalizing.
Well, I don't know what I saw on the system and printed out this morning, but it didn't show server.
I checked with ANDFLAN on your sheriff website and there's 0. I'd do that, that's kind of. I've done a few myself. Yeah, Derek's got a new charge, but why is there, was there a motivation that was looking for the more? Modification. So if you can still have an 18 case, what's going to be this 2020? Here it is. Years ago, I feel bad. However, your bishop was in as so he got hauled up. He usually has his hair twisted. He comes in. It's a signature bond. It's here. I've looked at it. The warrant says 5,000 signatures. Do you have a bond amount on that warrant for Bowman?
No, that's your maximum.
All rise, please. Circuit Court is back in session.
This one was already served.
Please. Crystal? What's your last name, Mrs.? Canizaro.
I don't have on this. Come forward.
We're trying to find out where you're supposed to be.
Yeah. What's your name now?
Crystal Canizaro.
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 You have a case number?
Not with me, but I know I have court today.
And what type of court do you have today?
It's for a felony charge.
For a felony charge?
Cannizzaro. It was like possession of a minor.
Okay. It's this afternoon at 1:30, ma'am.
Okay.
You have a plea date.
Does the court want to go ahead and do her?
Yeah, we'll do it. We'll do it.
What's the name?
Canizaro. C-A-N-N.
Canizaro. Crystal Marie. I got it.
Okay.
So this is case number 2023 CF 1123.
Canizaro, C.
No information's been filed yet.
Your Honor, her prosecutor isn't here. This is with Misc. This is with Christine.
We may want to bring her back for that, Your Honor.
There's no information anyway.
There's no information that's
filed.
But we don't know what the state's position is as to why they have, because Ms. Bossa would have filed that information already. So that would be my...
Ms. Bossa is going to be in a hearing with me at 1:15. She said that was all she had this afternoon. I didn't even know.
Your Honor, can she get the one-page application from the public defender? I've handed her a card with my assistant's name on it. She can schedule an appointment, and we can discuss what's in her best interest.
Why don't we go ahead and just enter a plea, and then she can deal with it.
There's no information.
There's no information, okay? So we need to come back on, what's our next?
July 11th.
What's that?
July 11th.
July 11th at 1:30. So what's happened, ma'am? The state has not yet formally charged you. That's what the information is. And so you can't plea until they charge you. They got to tell you what you've done. what they're claiming, okay? So, so we'll come back, we'll give them a month to try and resolve this. This will be at 1:30 in the afternoon. So July 11th at 1:30. And you can meet with your attorney in the meantime, okay?
Thank you, Your Honor.
Okay,
Thank you, Your Honor.
Okay, Mr. Noakes, let's try and do yours.
Morning, Judge.
Good morning.
I've got Mario Lee on motion to modify bond.
Okay. This is case number 23 CF 148. You may proceed.
He's got a bond on $1,500 cash. Can we get Charmaine Lee into Mario Lee into the
Your Honor, Marty Noakes on behalf of Mario Lee, 23 CF 148. Judge, my motion cites that Mr. Lee was arrested January 13th on count 1, 2, and 3, the most serious of which is count 3, which was trafficking fentanyl. His bonds were set at $7,500 on the theft of a firearm, $7,500 on possession with the intent to sell a manufactured controlled substance, and then $75,000 on count 3, which is the trafficking charge. Judge, in review of the arrest report, it was found to me that for whatever reason, when it was reviewed, there was no finding of or no finding without probable cause. For some reason, neither of those spots were checked. However, more troublesome is when you read over the arrest report, it just basically says that Mr. Lee was one of 3 people standing behind a vehicle, standing at the rear, and when law enforcement came on scene, that all 3 of these individuals decided to retreat into an apartment. As law enforcement was standing at the vehicle, they could smell marijuana. And then it wasn't too long after that, the defendants emerged from the apartment and began walking away from the officers. Officers attempted to speak to the defendants to conduct an investigation, but they fled on foot and were eventually caught. There was a search warrant applied for and granted, and actually one for the apartment and a separate one for the vehicle, because I believe that individual, there was another individual that was a driver that was detained out of the vehicle. There were illegal things found within the apartment, but no one was in the apartment. It's my understanding no one was in the apartment at the time that the search warrant was actually served. There's no allegations that my client actually possessed anything. Even though they've charged him with grand theft of a gun, there was a gun found, I believe, I can't remember if it was in the vehicle or in the apartment, but it had, based on the serial number, had been registered as stolen out of Walton County, but there's no facts putting my client anywhere stealing anything or possessing any illegal substances. So we're asking the court to consider reducing his bond. He cannot afford, I can have him testify as to what dollars he has available, and it's very few, in order to try to make a bond, Judge.
Your Honor, the state thinks that the bond as set is appropriate. Your Honor, I have let Mr. Nopes know that the officers that are listed need to be deposed because there is some social media surveillance and other surveillance that was done that will be a part of this case, and I've asked him to depose the I've given him the basic information about how his client will be connected to this apartment. I've asked him to depose those officers, and I do believe he reached out for some dates, and I think this is one of the cases, Mr. Nopes, that we were trying to get the depots on. But Your Honor, this is a trafficking case. It does carry a minimum mandatory.
So a couple of things that are unusual about this case, and I kind of need to walk through it. So, as I understand, Mr. Nopes, you're essentially contesting probable cause.
Yes, sir.
And so, but it's not contained in the actual order. Are you prepared to discuss probable cause? I'm a little bit concerned that although probable cause was listed, you don't make clear that you're making a probable cause argument, and you don't list the specifics, which doesn't give them a chance to. This is very serious charges. If this was, these are very serious charges.
Judge, and if I could, the state did mention to me that there was going to be some social media information coming. They did send us some pictures and what have you, but from what I can tell, there's only one of those pictures that is my client. He only appears in one picture, and in that picture, from what I can see, he's simply sitting on a counter next to a refrigerator in a kitchen and appears to be wearing a hat, shirt, possibly shorts, and smoking what appears to be a cigarette. I guess it could be marijuana, but I can't tell either way. So I'm waiting for the other shoe to drop where there's more evidence.
I think, first of all, I happen to be the one doing the first appearance. And that was Scrivener's error. It should have been listed, should have been circled. Everyone who's done first appearance know we got a stack of documents we're signing left and right. So the court finds that there is probable cause. I think as to the probable cause argument, this is something that would be more appropriate for a motion to dismiss. We can lay out the facts in great detail, the state can contest those, and we can address at that level. And as it relates to the amount of assuming there's probable cause, which I'm making a ruling that I did find that, the court doesn't find that the bonds are unreasonable at all. Matter of fact, could have been worse when you have the scourge of fentanyl in basically amounts that lead to trafficking counts are extremely serious issues. So, but I'm hearing what you're saying, and I just don't think we have enough information to really, get down to basically say, hey, there's no probable cause here. So, Ms. Sharpless?
Yes, Your Honor. What the court just stated about the Scrivener's error was exactly where I was going with that, because clearly Judge Ward put amounts next to each count. So that
Judge Ward had done it, but Judge Ward didn't do it. Judge Ketchell did it. I did.
I thought I saw Judge Ward's signature, Judge. I'm sorry.
I was first appearance on this.
And I saw, and everything else is circled except for probable cause. So that's exactly where I was going.
I don't have any questions regarding
And I agree with the court that this may be more proper for a motion to dismiss. And if that occurs, I would call officers. We would need to have a hearing. So,
well, it seems to me that you know, on a case as serious as this, and you know, and it goes for both. It's a serious charge, but you know, defendants have rights. So the state's got to prove their case, which is a very significant burden. But in order to really address the first level, the motion to dismiss, the allegations and the countervailing arguments by the state have to be laid out in more detail. So I'm going to deny the bond reduction, but understanding that it would not be unreasonable to see some motion to dismiss and the state can lay out some of their basic contentions.
Yes, sir. I understand.
Okay.
Thank you, Your Honor.
Your Honor, should we, I don't know if this case is already set for, before Mr. Lee leaves the room, I don't know if this case is already set for the next pretrial date.
8/16 is when it's set for.
8/16, correct. And if you get a motion to dismiss, we can get it on the miscellaneous dockets as quickly as we can.
I understand, Judge.
Thank you very much. Okay. Who's up?
Are we ready for what the two pleas, the last in person?
Yeah. What?
The last two pleas in person. We can get them
Mr. Arnett and Ms. Burnett.
Arnett.
Okay, those are we didn't have attorneys, right?
Yes, Your Honor.
Would you give me the plea?
Absolutely.
So, there is a plea agreement that's been typed up, Your Honor. Mr. Arnett and I have, I believe, both signed that. At this time, Mr. Arnett is willing to admit the violation. The state is suggesting that his probation be revoked and terminated, that he be given 180 days to pay the remaining financials, or the remaining financials will go to a civil lien. There's a mandatory 6 months driver's license suspension, and the $100 VOT fee. Your Honor.
Very good. Mr. Arnett, would you raise your right hand? If I swore you in, I got to do it again. You swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God.
I do.
So, Ms. Sharpless, you need to sign. So, I was just reviewing the plea agreement that you have signed, Mr. Arnett.
Yes, sir.
You understand it. First of all, did you read through that closely, make sure you understand it? I know you're not a lawyer, but
yes, sir.
It has a lot of legal stuff in it. The big thing that is contained in that agreement from a legal standpoint is that you're waiving a number of legal rights in order to get a final resolution. In this case, it's a pretty straightforward resolution. They're going to revoke and terminate, which means they're going to end probation for you. I mean, you've got 180 days to pay your court costs, and you've got a mandatory 6 months drive. It's all that's pretty straightforward, but I want to make sure you understand that.
Yes, sir.
And there will be an adjudication of guilt on this based on this violation of probation on both counts. You understand?
Yes, sir.
Misdemeanor counts are not felonies.
Yes, sir.
But you will be adjudicated guilty on those. Do you understand that?
Yes, sir.
Do you have any questions concerning any of this? I know you're not a lawyer, but do you have any questions? Pretty straightforward stuff.
No, Your Honor, I understand.
Very good. So the court will accept the plea agreement and revoke and terminate. You've got that 6 months driver's license, and there will be no objection to the defendant obtaining a hardship license if you're eligible. Okay?
Yes, Your Honor.
Good luck.
Yes,
30 days to appeal.
30 days. Even though you just entered into this, you do have 30 days to appeal this agreement you just entered into, ma'am.
Your Honor, Ms. Burnett is back on her case numbers, or her case number, which is 22 CF 2281. Your Honor, at this time, Ms. Burnett has indicated to me and to the court previously to this being reduced to writing that she wishes to admit this violation. adjudication would be withheld, her probation would be modified and extended for 6 months of drug offender probation, followed by 2 years of probation. Ms. Burnett indicated that she has spoken with the probation officer about what all this means, and she understands that and wants to do that. She understands that this will extend the current probation term that she's on, and it will extend her probation, her termination date past what she was originally anticipating, but she's indicating that she wants to do this. Ms. Burnett understands that she's going to have to complete all the original requirements of her probation, and that she's going to have to pay the $100 VOP fee.
Okay.
And Your Honor, Ms. Burnett did plead to felonies, unlike Mr. Arnett, so a score sheet is required. It did not print correctly, so I had to reprint it. I will hand it into Your Honor before court ends this morning. She's going to score a total of 29.2 points.
So she does not score for jail?
She does not score for prison.
Okay. Ms. Barnett, I think I might have sworn you in, but I'm going to swear you in again. Raise your right hand. Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
I swear.
So, Ms. Burnett, I'm looking at the VOP plea and sentence recommendation. It's actually an agreement. And it has the terms of the plea agreement that Ms. Sharp was just laid out to you. Again, this is pretty straightforward. I just want to make sure you understand what you're doing and that it's free and voluntary. Do you understand that probation is going to be modified and extended to include 6 months of drug offender probation? And probation's gone over, explain what that is, a little higher degree of supervision,
yes,
tracking a little more closely, followed by 2 years of regular probation. And then you've got to complete all your original requirements, the substance abuse treatment, etc. That's probably the most important thing of this, and it sounds like you're, willing to do that.
Yes, Your Honor.
That's perhaps the most important thing, that you're on board. If you're not on board on any of this stuff, we can do all we want. Ain't nothing going to happen good unless you make the change.
Yes, Your Honor.
Okay? So you're being given another opportunity, but you understand that by entering into this, this takes care of the violation, and this will be a final adjudication of the violation of probation. You understand that?
Yes, Your Honor.
Do you have any other questions concerning how this affects you legally?
No, just wanting to make sure the adjudication withheld is still on.
Correct.
Okay, that's the only question.
According to this, it's continue to withhold adjudication, right, Ms. Sharpless?
Yes, Your Honor, that is the state's agreement.
And of course, that is a very important consideration, so that's a good question. Anything else?
No, Your Honor.
Okay, thank you very much. Good luck.
Thank you.
Okay. Mr. Morrow, are you up, or Mr. Medina?
Most of what's left does belong to me, but if Mr. Medina or Mr. Gates
Whatever
wants to get theirs out of the way.
I always let you fight on jury and let them call the doctor.
Well, now I know who his are, so if you just, however you guys want to go, it's fine. I know you. It starts with 24, Caleb Gordon. It looks like we're just going in order from here on out.
It's easier to follow along in the document.
Okay.
Mr. Hall is going to be, if we would put him behind number 28. Robert Hall, if you would put him behind number 28, that way he can do all his, he has 29 through 39.
But he doesn't have to come back until 2:30.
Yeah, so he has this attorney, so Mr. Hall is number 20. So you should be Caleb Gordon. Caleb Gordon's the left one. Caleb Gordon.
Your Honor, this is Mr. Gordon before the court in 22 CF 10, 22 CF 41, and 23 CF 1062 We have a plea agreement to be filed that's going to cover all 3 cases before the court, Your Honor. So on the approach.
Is this defendant?
Caleb Gordon.
Thank you.
Could you announce the plea? Just before we let me go to score sheet with Mr. Gordon real quick. And Your Honor, the plea agreement is going to be for 9 months. Of course, she shows 14 months, so that was partial for a plea.
That's correct, Your Honor.
Based upon the negotiations with the state. Very good. I would also say, based upon my conversation with the state, the victim in 21 or 22 CF 41, there was a victim in that one that was okay with the 9-month kind of adjustments as well.
That's correct.
Very good, thank you. Mr. Gordon will be admitting the violations in 22 CF 10 and 22 CF 41, pleading no contest as charged in 23 CF 1062. In the violation probation cases, we're going to revoke and terminate his outstanding supervision, sentence to 9 months in the county jail on the felony counts, time served on the misdemeanor counts, standard court costs, 100 cost of prosecution, 150 public defender fee, 100 public defender fee in the other case. And then the new case, Your Honor, on count 1, the felony count will be sentenced to 9 months in the county jail with credit for all time served. Count 2, time served. 615 court costs, 100 public defender fee. Mr. Gordon would ask for 24 months from his release date to pay those outstanding fees. Is that the agreement?
Is the agreement, Your Honor.
Thank you, Mr. Gordon. Would you raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
So you heard your attorney state the terms of the plea agreement, and those same terms are contained in the written plea and sentencing agreement that you've signed. Have you read this plea agreement closely?
Yes, sir.
Have you gone over it in detail with your attorney, make sure you had all your legal questions answered?
Yes, sir.
You understand that by entering this, you're waiving some valuable legal rights. The big one is the right to go to a trial, force them to prove their case beyond a reasonable doubt. You believe that's in your best interest?
Yes, sir.
You understand this will be a final resolution of your case?
Absolutely, yes, sir.
Okay. Very good. Based upon that, the court will accept your plea agreement. I think your attorney laid it out succinctly. Revoke and terminate probation on all the probations. All the felony charges will all be, you'll be sentenced to 9 months county jail. They'll all be concurrent with one another, and that's both with the VOPs as well as the new law charge. All of the misdemeanor charges will all be credit for time served. You've already served that time; those basically will go away. And all the standard fees and costs that are contained in the agreement, and you will have 24 months from the date of release to pay the court costs. If not, they'll go to the lien.
Yes, sir.
Any questions?
No, sir.
Thank you.
Thank you.
Right this way, Mr. Gordon. You can get your fingerprints. You also have 30 days.
You got our next. You have 30 days to. Your next is going to be Ronald Hartzog before the court. He has 22 CF 2492, 22 CF 3036 on the morning docket. He also has 23 CF 1112 on the afternoon docket. And the felony docket? Yes, Your Honor, it is. Okay. Your Honor, after speaking with Mr. Hartzog a little bit 2 seconds ago, if we can pass him to the afternoon, it sounds like he's agreed to the state's offer, which is a guideline sentence covering all 3 cases. Okay. I'll have the plea agreement up and go over that with him this afternoon. Very good. Thank you.
He has to read it this afternoon only because he's pleading, so that everything's going to be doing the
Okay. I think the next one is Atkins, which is Mr. Medina.
Yes, Your Honor. Atkins?
We have an agreement with Mr. Atkins, Your Honor. Okay.
I'll be approaching with the agreement, Your Honor. I'm just making sure what that's on my phone.
I'm approaching the agreement.
Thank you.
He's maintaining his withhold adjudication, but Mr. Sharpless is going to provide a score sheet. I'm not sure it's required in this situation, but under this agreement, Your Honor, he will be admitting to the felony violation of probation. He would reinstate and modify. Oh, Your Honor, I'm so sorry. People have not signed it. We've been over it, but it is not signed. I do apologize to the court. Under the agreement, Your Honor, he would admit the violation, reinstate and modify to add a special condition of 6 months jail with credit for all time served and with probation to automatically terminate upon release. In essence, this is a way for him to accept the state's 6 months jail offer without becoming a convicted felon. So he would maintain his withhold of adjudication. There would be a $100 VOP fee and $150 public defender fees.
State agreement.
Yes, that's the state's agreement.
Would you raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
Okay, so you heard the terms of the plea agreement. I see you've signed the written plea agreement. Have you read through this thing closely?
Yes,
Gone
sir.
over it with your attorney, made sure you had all your legal questions answered?
Yes, sir.
You can put your hand up. And so I just want to make sure you understand basically the core of this is that you're going to receive 6 months jail with credit for time served. But when you get out, probation will end, so you'll be finished with that when you get out.
Yes, sir.
You understand? You got some fees and costs, etc. You understand you'll continue with the withhold, which is important to you. You understand that by entering into this will be a final adjudication of your case. You don't have to come back and go to any more hearings. Do you understand that?
Yes, sir, I do. I was just curious if I would get time served for the 60 days I did.
Your Honor, I advised him that whatever prior credit, if it was just on this case that he's entitled to, he would get. I already advised him that the court can't provide confirmation on that issue.
It's just not something we calculate. So
Okay,
I wouldn't, even if I wanted to, I couldn't give it to you.
Yes, sir.
Your Honor, there was one other detail I apologize that I failed to write that he mentioned when he had the agreement, and that was, could he have 6 months upon release to pay his monetary obligations before they would go to collections?
That's fine.
That doesn't mean you have to pay them, but that way they don't go on your driver's license. So your unpaid monetary obligations would go to collections after 6 months or after release.
Yes, sir.
Thank you. Thank you, Ron.
Okay. Thank you. Good luck, sir.
Thank you,
Sir.
Billy Balkin?
Thank you for your help, sir.
Your Honor, thank you, sir. Good luck. Your Honor, Mr. Billy J. Balkin is approaching in 21 CF 1742. May I have a second with him? I got some information. Your Your Honor, at this time, Mr. Balkin, I've advised him of the state's position, which is that the state is unwilling to reinstatement and modification, even with a suspended sentence at this time. I believe that he wants to go ahead and deny the violation. He is of the position that he should be able to get a reinstatement and modification under these circumstances with the first violation, but since Ms. Sharpless won't do it, we need to deny the violation.
So we'll deny and come back how far out? July 18th?
I don't think we need that much time. He anticipates resolving the misdemeanor trespass in the near future. Do you know when your court date is on that?
July 31st, they already said within 1 vote.
July 31st, we need to come back after that then, Your Honor.
August 17th.
Okay, thank you.
And that will be in the morning at 9 a.m.
Thank you.
Corey Clark.
Yes, Your Honor. Sorry, Mr. Balkin. Mr. Balkin. There was also a specialty court the state was possibly willing to consider. If you decide you want to get evaluated for that, please let me know, okay?
I already told you it's okay.
Okay, well, I will get him evaluated for a specialty court, Your Honor.
Okay, good.
I apologize for not mentioning that when he was before the court. Okay, go ahead and sign that. Your Honor, this is Mr. Corey S. Clark. We have he's before the court in 22 CF 2744, and he's worked out a 30-day jail deal to resolve a misdemeanor DOP. That was the probation recommendation, I believe.
It was, Your Honor. And this is a misdemeanor, so it won't require a score sheet.
Under the agreement, Your Honor, Mr. Clark would be admitting the violation. There would be 30 days Okaloosa County Jail. It's revoke and terminate the probation, and it's with credit for all time served on the 30 days. There would be $100 VOP fee and $150 public defender fees. I may not have written on there some time to pay. Can he have 90 days upon release to pay the outstanding monetary obligations?
Sure.
Thank you, Your Honor.
Okay. So, Mr. Clark, I just need to ask you a few questions about your plea agreement. Would you raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
So you heard your attorney state the terms of your plea agreement.
Mm-hmm.
Is that your understanding of what the plea agreement is? I see it's in writing and on the written plea form as well that you signed.
Yes, sir.
And is the state in agreement?
Yes.
Just wait and get it back from you. Ask you just a couple questions about it. You understand that by entering into this plea agreement here today, by entering into the plea agreement, you're waiving the right to go to a trial, and there'll be a final resolution of this DOP.
Yes, which is fine.
Here today?
Yes, sir.
Okay. And the core of this, obviously, is the 30 days jail. You will get credit for all time served. You got some fees and costs to go to collections after 90 days. Okay. Any questions?
Not at the moment.
Okay. Very good. Thank you. Good luck.
Thank you. Your Honor, I know it's a small case, but I guess he has 30 days to appeal.
Yes, you do have 30 days to, I have to tell you that. You have 30 days to appeal this.
Thank you.
Thank you, Your Honor.
Ryan Morrow from Mr. Your Honor. I was recently appointed to this case. I just filed my notice yesterday. The state did manage to put together an offer for us, but it involves the Keaton program. What I'll ask is that the court put us on 718, and then in the meantime, we'll have Mr. Hall evaluated for that program, and we'll follow up on the case and let the court know where we're going. In this matter, if it hasn't already been done, we'll issue a denial for the court record.
What is your case number? Because I don't have that. Is that a new edition?
I had it under a private attorney, but.
Who'd you have it under?
It didn't have the name of the attorney. It just said it was a private attorney. Not a 13 deal.
Yes, I've got a call. Someone tomorrow.
I just filed that
Yes.
last night after hours, so that's.
So we're denying.
Yes, Your Honor.
Denying the DOP will come back when?
718, Your Honor?
Okay.
That would be all right.
All right, 7:18 at 9 a.m.
Right, Mr. Ronald Alloway.
Ryan Morrow for Mr. Ronald Alloway. This is 22 CF 1657. Mr. Alloway has asserted a desire to plead to the court. Do you have your paperwork, Mr. Alloway?
Yes, sir.
Okay. May I have a moment, Mr. Alloway? Your Honor?
I'm sorry?
May I have a moment away?
Sure.
Sorry for that delay, Your Honor. This is going to be a plea to the bench, but the state has agreed to cap the incarceration aspect at what Mr. Alloway says, and I want to include that in the written plea.
Your Honor, it's 22.95 months.
Is that the minimum guidelines?
And I will get a spreadsheet at sentencing.
Yeah.
So there is no agreement, Your Honor, in this case. It's going to be a plea to the bench, but with the guideline cap on incarceration of 22.95 months. I'll pause and give Mr. Alloway an opportunity to sign. May I approach, Your Honor? And Mr. Alloway is prepared to be sentenced. I understand that we may need to be set off for sentencing hearing. I'm going to put the state at a little bit of a disadvantage, but he is ready to be sentenced whenever the court and the state is prepared to have a hearing.
Okay. Well, I just need to ask you a few questions, make sure you're entering into this freely and voluntarily. Would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir, I do.
So I heard your attorney state the terms of the plea agreement, and those same terms are contained in the written plea agreement that you've signed?
Yes, sir.
And so have you read through this plea agreement?
Yes, sir, out there. And then what he just wrote on it.
And have you discussed this plea agreement with your attorney?
Just right now, yes, sir.
And you believe this is in your best interest? There's a cap on the incarceration. You're pleading to the bench. In other words, that's just, this isn't a firm agreement as to what the sentence would be, but you have a cap, top
yes,
end of it, but not a lower end. So your attorney will have to argue for lesser than that. And of course, pretty certain the state will be arguing for the full amount.
Yes, sir.
Right? You understand that?
Yes, sir, I understand.
Okay. And is the state in agreement with this?
Yes, Your Honor, that is the state's agreement.
And you understand this will be a final resolution of this portion of your case, not of the sentencing, but of what you're agreeing to. You can't change your mind after we enter into this today. You
Yes.
understand that?
Yes, I understand.
Okay. Very good. Based upon that testimony, and court will accept your plea agreement, and there'll be, and we'll set the sentencing off. It is agreed that there's an adjudication of guilt in the charge. You understand that? And we'll set off the sentencing with the 22.95 months DOC cap on incarceration. State? How far out do you need?
Well, I don't think we need to go very far, Judge. If we want to set this on 7/11, I just need to get in touch with the officer to find out if they would like to come to court and speak with the court in regards to sentencing. I will email them and find that out, but otherwise...
Do we need to get a PSI?
I was not going to request a PSI in this case, Your Honor, but if the court would like one,
It's not, I'm sorry, I don't remember the state. It would be required in this case if it was required, the defense would waive it. If we needed a PSI based on what we saw last time, we needed one. I think that would require 40 days, so we wouldn't be able to come back on 7/11. For the court's awareness and for the state's awareness, the reason that Mr. Alloway is trying to move this along is he's going through custody proceedings. He had recently fathered a child, and he's seeking reinstatement so he can work that case plan, Your Honor.
Okay.
And it pertains to doing drug treatment, substance abuse, domestic violence, parenting, and all that is in my case plan, and they're giving me. I just got it today, and they're giving me like 9 months to complete it, and I'm really trying to get custody of my son.
So we would request
Is this a dependency case?
Yes, sir. Okay. With Judge Powell, Lacey Powell.
Who's your attorney?
I got it right here. I just received it. I got my hands full here. Right on top of the paper here.
Okay, we look for
It's a name that he wrote.
They wrote it?
Yeah, he wrote it on top of one of these.
So Steve Ryan.
Okay,
Yeah,
that's correct, Your Honor.
You just need to listen to him. What you're explaining isn't exactly correct, but I understand. So the court will waive the PSI.
Thank you.
Proceed with it. We'll go to what do we have in the afternoon on the 11th and 18th? Which one? So we'll schedule the sentencing on July 18th at 2:30.
What date did you give? Was that the 11th?
July 18th next year.
Understood. Thank you, Your Honor.
Thank you. Yes, sir. Thank you.
I got all my papers right.
This was already here.
Sean,
Well,
so for you, all you attorneys, when you have a dependency action separate a case plan like he's doing, and you get incarcerated, it's essentially a base dependency action. It's actually a benefit. They're not going to hold it against. He's trying to get past the 9 months. If he goes into DOC, they won't hold that against him. He'll be able to get it when he gets.
understood, Your Honor. I'll advise on that.
No, you don't have to advise him if you're not his attorney on that, but just so that you guys understand how the interplay is a complex interplay when dependency gets to the crew down.
This is Sean Billstein, Your Honor. 22 CF 1714. This is going to be a negotiated plea on the VOP. The agreement of the parties contemplates that we'll ask the court to revoke and terminate the supervision. Sentence Mr. Billstein to 13.85 months Department of Corrections with credit for all time served. $100 VOP fee, $150 cost of defense. All financials are reduced to lien 1 year after his release. He was previously adjudicated, Your Honor. And I'll pause and let Mr. Billstein have an opportunity to sign.
The state agreement.
Yes, Your Honor, that is a state's agreement, and that that number that Mr. Morrow announced is his lowest permissible sentence, 13.58 months.
May I approach, Your Honor?
You may. Mr. Billstein, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
Okay, you heard your attorney state the terms of the plea agreement, and I see those same terms are contained in the written plea agreement. Have you had a chance to read this closely?
Yes, sir.
This plea agreement, and have you gone over it in detail with your attorney? Make sure you had all your legal questions answered about this plea here today.
Yes, sir.
And you understand that by entering into this plea, you're waiving some valuable legal rights. The big one is the right to go to a trial and contest this, force the state to prove their case. You're waiving that so you can get a final resolution today. Do you understand that?
Yes, sir.
Do you believe that's in your best interest?
Yes, sir.
Nobody threatened or coerced you to get you to enter into this?
No.
Okay. Very good. Based upon that, the court will accept your plea. The court will revoke and terminate probation and sentence you to 13.85 months DOC. You will get credit for all time served. And you've got the standard fees and costs. It'll be submitted to does it go to lien upon release? You can't read your writing.
I'm sorry, Your Honor. I prefer to type those up. The agreement contemplates that the last court can allow the financials for the release lien 1 year after his release from DOC.
Okay, 1 year. Okay, that's what I couldn't read. 1 year after release. Okay, so you got a year to pay out if you get it before you goes to a lien. If it goes to collections, it affects your driver's license and stuff. You can pay it in that 1 year. Nobody's gonna, you're not going to be violated, you're not going to get kicked out, but it will affect, will be on the record. Okay?
Will the court advise him as to his appellate rights?
Yes, sir. You do have a right, even though you just entered into this, you have 30 days to appeal this. Okay?
Thank you.
Thank you.
Yes, sir.
Your Honor, that wasn't adjudication.
He's adjudicated and previously adjudicated.
Yes. Thank you.
Jose Mooney?
Ryan Morrow for Mr. Booney, Your Honor. This is 20 CF 1983. Defense is still waiting on a mitigation evaluation from a defense expert as well as 2 evaluations from inpatient treatment facilities. Defense is requesting this can be continued to 7/18. I understand the court advised that this prior continuance would be the last one, but we are still waiting, Your Honor.
We'll continue this to July 18th at 9 a.m.
Thank you, Your Honor.
Okay?
7/19.
And Your Honor, just for the record, this case was, prior to me going out of town last week, it was still on the docket for 6/22, and it was set for an benchmark said it was set for an evidentiary in the afternoon. That has now been removed. I just want to make sure that it's actually been removed and I can cancel my subpoenas for the day.
Did everything go well with your out of town?
Yes, Judge. And I thank Ms. Sandler for covering me.
She said she's extracting some serious considerations based on all the hard work she had to put in while you were gone.
Andrew Flannery?
Brian Morrow for Mr. Flannery. Your Honor, this is to be a negotiated plea as to the VOP, but before we do that, the court deputy has raised a concern about an outstanding warrant for Mr. Flannery. When I was looking at it, it appears as though it's within this case. So we wanted to get that served and ascertain that that was the case before we move forward with the plea, because it contemplates bars to Beth Keaton, and I don't want that to get tripped up.
Sure. Is it like you know what the warrant is? Failure to appear warrant?
It was a violation of probation is what it looked like. I don't know if it's a new violation of probation, I believe. So.
And the paperwork that I saw that the deputy had, it reflected Your Honor's name on it. So it's my anticipation that it's either duplicative of this violation or within this violation. I don't know if the state has anything else. Mr. Gates has checked the information available to him, and we don't see anything else outstanding.
I don't have any information. This is the first I'm hearing about the warrant.
We've got to figure it out, get online and figure out before we, he's not going to want to enter into a plea with an outstanding warrant. He doesn't know what's out there.
My understanding was that was taken back to be served on him. Has it now been
But
served?
it's not been served.
Okay.
No, we had him upstairs. We can bring him back. We can take him downstairs and bring him back this afternoon or whatever.
Well, we gotta figure out what it is first.
Right.
We don't know what it, I don't know what's the warrant.
It pretty obviously to me looked like a.
Why is the warrant out there?
He was in violation and he was served with that warrant. I don't see anything that's going to be in violation.
And I had probation check, and probation said there's no addendum in their system either. So unless the state who has access to other stuff can tell us what that warrant may be.
We're working on it right now.
Okay, you wanna just hold on that?
That'd be great.
Why don't we just hold on this, Ms. Morrow, Ms. Flannery, we'll try and work it out so you can get this resolved by today.
Thank you. May I have one moment?
If it's on this one, we can just withdraw. If it's something else, we gotta know what it is.
Jeremy Gaffer.
Ryan Morrow for Mr. Jeremy Gafford, Your Honor. This is 5 CF 13, 5 CF 14, and 5 CF 279. I believe this may be a first time up for Mr. Gafford. I'll enter a denial if that has not already been done. The state's offer in this case is to reinstate Mr. Gafford's probation and offer him community control, but the concern from the defense perspective is housing. So what we're going to do is we're going to ask to continue this matter to 7/18. We're going to have Mr. Gafford evaluated for some inpatient facilities as well. You do have housing?
I got an address. I got my boyfriend to get out today. That I can have my job back and I still have my room. So if I can leave you, I need the address, phone number, and a place that I'll be working in.
Going to put them at the end of the
Yeah, maybe bring back stuff. Your Honor, it sounds like we may be able to resolve Mr. Gafford's case, but I want to make sure that he is going to be able to be successful in community control.
I understand, Mr. Gafford.
Ryan Morrow from Ms. Greco, Your Honor. This is 22-2564. This is going to be a negotiated plea on the VOP in that matter. The agreement of the parties contemplates that we'll be asking the court to revoke and terminate the supervision, sentence Ms. Greco to 3 months county jail with credit for all time served, $100 VOP fee, $150 cost defense, all financials to reduce lien after 1 year. From her release, she's previously adjudicated. Pre-sentence report will not be required. I'll pause and give Ms. Greco an opportunity to sign.
I have the score sheet here. May I approach?
You may.
Thank you. So tomorrow, you need an opportunity.
You're in agreement with the adjourn? You're in agreement with the
Yes, Your Honor, that's correct. And she does not score, so this is not valid.
Sure, thank you.
Thank
This
you.
is also included as
May I approach, Your Honor?
You may.
As Ms. Greco has rightfully brought up the failure to appear, we're asking the court to take no action on the failure to appear in recognition of the plea today.
Are you okay with that?
I'm fine with that, Your Honor.
Needs to be in here. Is it in here?
It's not. May I approach? May I approach?
Ms. Greco, would you please raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
Okay, so, Ms. Greco, you heard your attorney state the terms of your plea agreement, the core of which is basically revoke and terminate supervision in 3 months in the county jail, credit for all time served. That's the key. Have fees and costs that'll got a year to pay. Court will take no action on the failure to appeal. Okay, do you understand? Is that your understanding of the agreement?
Yes, sir.
Do you have any questions regarding this agreement?
The only question is that it actually, when it gets sent over to the jail, that the no action on the FTA is actually written in there, because they'll restart my time over if not. Thank you.
The FTA is written in the agreement.
Okay.
Okay. I don't know exactly what you're actually referencing, but
Well,
it's in
whatever
the
time I have
agreement.
credit for right now, they actually don't start your time until the last charge, which is the failure to appear.
Okay, well,
In other words, I wouldn't get credit for the time that I've already served in before I came in this time.
well, does this solve it? You need to ask your attorney. Does this solve it?
To my knowledge, Your Honor, that's any time that I have an FTA that was pending in a case or that is now being pled, that's the exact thing that I would do in any individual case.
And I agree. That's why I'm not a little bit unclear what she's referencing. But it does say in writing, your FTA is not going to be, no action will be taken on your FTA.
Thank you, sir.
Okay, so you understand this will be a final resolution of this matter, you're waiting to go to a trial.
Yes, sir.
And you believe this is in your best interest here today?
Yes, sir.
Okay. Based upon that, the court will accept your plea, revoke and terminate supervision, sentence you to 3 months in the county jail, credit for all time served. No action will be taken on the FTA. Fees and costs, you'll have a year to pay in before they go away. Good luck, and you have 30 days to appeal this.
Thank you, sir.
Thank you.
Hillary Hartsfield?
Your Honor,
Yes, sir.
I figured out the warrant when you have time to call back Mr. Flannery.
Okay.
Ryan Morrow from Ms. Harshfield, Your Honor. This is 21 CF 2685. I believe this is the first time up from Ms. Harshfield. I'll enter a denial if that has not already been done. The state has offered Keaton. The state's offered Keaton. She's not yet been evaluated. She's kind of indicated that that's not her intention at this point. I'm going to have her evaluated anyway, all the same, since that is the state's offer, and then we'll come back in July and let the court know which way we're headed, Your Honor.
Okay, so we'll continue this to 7/18 at 9 a.m.
The state said they figured out that warrant, so I'll let you know as soon as I find out.
Thank you very much.
We're gonna skip, Joseph can go to Shannon Locke. We need the female one, Shannon Locke.
What's the deal with the warrant?
Your Honor, it's within the same case as for felony ways.
So you can withdraw it?
I think we can just withdraw it or quash it. And
Okay, we'll bring it back out in now.
thank you.
Ryan Morrow from Ms. Locke, Your Honor. This is another case where the state is offering a treatment program resolution.
Is this Shannon Locke?
It is, Your Honor. Shannon Locke, 22 CF 3003. We're going to ask to be continued to the July date, and we will have her evaluate those programs, and hopefully we'll have a resolution at that time.
Very good. The court will enter a denial on behalf of the defendant. We'll come back on 7/18 at 9 a.m.
Great. Joseph Hopkins?
Or you want to bring out Flannery, I'll do that.
I'm going to have to talk to Mr. Flannery about the offer. He's indicated that he may not want to accept the state's offer, so that we might be back starting from scratch, Your Honor. Ryan Morrow for Mr. Hopkins, Your Honor. This is 22 CF 34. The defense is still waiting on 2 inpatient facilities to hear back from whether or not Mr. Hopkins will be approved for that. And I'm also still waiting on a psychological evaluation from Dr. McDonald. I'm asking this to be passed the 7/18 date.
State, okay with that?
Yes, Your Honor, that's fine.
You're good. The court will come back on July 18th at 9 a.m.
Darren Taylor.
Ryan Morrow for Mr. Taylor, Your Honor. As he approaches, it's 19 CF 2910, 21 CF 250, 22 CF 1746, and 22 CF 2182. Mr. Taylor would like to have a Nelson hearing, Your Honor.
Has it been filed?
He has already
filed a motion. You filed something.
It was requested during our meeting yesterday. He just told me that he'd like to have a Nelson hearing.
So what you need to do is you need to file something, file a request for a Nelson hearing, okay, and then it'll be put on a calendar.
Yes, sir. Matt, can I speak, Your Honor? Sure. Since I was put on CC, Your Honor, I was homeless when I first got put on CC. I'm here for a dirty urinalysis test. If I wasn't positive for a drug test, Your Honor, I wouldn't be standing here before you today. I was doing everything with my CC as far as reporting. I had a job. I was complying with my CC report. I mean, the schedule every week. And Your Honor, I'm a drug addict. I'm trying to get this resolved. This is like my second or third court appearance on the drug. I need help. I need treatment. I'm asking the state if I can get some help.
We'll certainly look at that, you know. And hey, I'd be lying to you if I told you that I'm satisfied with the kind of treatment available that we have in the system. It's not the best.
Yes, sir.
But we'll do whatever we can to try to deal with it. We want you to get help.
Yes,
but you know, a lot of times we don't have as many options as you might think we do.
Well, I was going to ask the state today if they could, because I had put an interstate compact in to go back to Oklahoma, but since I violated with the dirty urinalysis, my probation officer told me that would be canceled. So what I was trying to do, I was see if the state would be willing to do 1129 with me so I can terminate or revoke this probation. I was trying to get this resolved today, please. I would like to go back to Oklahoma.
Is there a plea on the table for this job?
State's offered a guideline sentence of 27.9 months. I have Mr. Losco's email. Me and Mr. Losco went over the docket last night after I met with Mr. Taylor. And Mr. Losco's offered, initially it was 32 months. Mr. Losco came down to his score, which is 27.9 months, Your Honor.
I mean, that's their offer. I don't get in the middle of negotiation. That's between you and the state. If not, you have the right to go to a hearing, and we'll deal with it then.
Mr. Losco? I can't talk to him.
Well, I mean,
Well, Judge, I mean, he's currently represented. I don't want to be negotiating.
No, I'm not asking, but Mr. Morrow's asking, did he state correctly what the terms were?
He stated correctly what my offer is.
Okay. At the end of the day, I don't think Mr. Taylor wants a contested hearing. I think this is either going to go the way of a negotiated plea or a plea to the court. I don't know if he wants to enter a plea to the court today, recognizing the score and the offer is what it is. But he has requested a Nelson hearing, so I just wanted to make sure that he has a chance to air his grievances before we move forward.
What do you want to do here today? I'm not trying to force you. You don't need to take any action whatsoever.
Yes, sir. I'm really just trying. I really was trying to get back home, and you know, my mother needs me there, and I really just want to get my probation terminated, and so I can just talk. Please, I'm begging the court to have mercy. So please, state give me 1129.
Your Honor, I would just like to point out a couple of things. First off, you know, his probation included intensive outpatient treatment, which he did not attend. Also, I'd like to point out that he keeps saying he wants to go to Oklahoma, but his girlfriend is calling the probation's office in saying that they're going to get an apartment together here in town and stay around. So I'm hearing a lot of different things from him, and I just think that
you have an offer on the table. It's done.
Thank you.
Okay.
But well, if I didn't, you know, because I didn't know for the treatment program, I said if I could get treatment, I didn't know, because I asked Mr. Morrow about the outside treatment at Bridgeway. If I got treatment here, I'll be more than welcome to stay here.
Stop. We're gonna, at the end of this thing, I'm gonna let you talk with your attorney. Okay? This isn't between me. You need to be talking with your attorney and see what's out there. So at this point, we're going to continue this till 7:18. But if you want to have a Nelson hearing, you can have that. Once you have a Nelson hearing, your attorney kind of gets clams up generally. So and he'll explain to you why that is. But if you want to talk to him further,
I have no problem talking with him. I at very least want to discuss with him what Mr. Bosco presented last night after I met with him, because
if you want to bring it back this afternoon, you can.
Absolutely, Your Honor.
Bring it back this afternoon, you got it.
Okay.
Yes, sir.
Come back this afternoon.
We got a few more cases then.
I'm going to be here anyway for Mr. Griffin's sentencing, Your Honor, so it's not an issue for me at all.
But 1:30 then you want him back to it? We only have one more inmate. So
you want to talk with him?
I'm here, Your Honor, so that's just fine. Whenever it's convenient for the court, I'll talk to him now, or whenever the court wants to hear his case. And he does want to have his matter heard today, if he can, it sounds like.
Okay.
And I have time to discuss everything that's been said with him today, before I leave to go prepare for my other sentencing hearing at 2:30.
Okay. What do we have left other than this? You got one more case, right?
We have, and then we have one more of him, and then we have one.
Mr. Gates got one. Okay. Why don't you send it back and then he can.
I believe the next one's going to be mine for a plea, Your Honor, Mr. Willis.
The problem is we run out of time. Everyone's going to be bailing.
Yeah,
for lunch.
They're going to go to lunch too, so he won't be able to sit back there and talk to them.
I know.
He'll have to go to the jail and talk to them.
That'd be fine.
Okay. Very good. Thank you.
So that's for 7:18, Your Honor? Did I understand the court's order correctly? Okay. Thank you.
Correct. 7:18 on that. 7:18. Nothing else happens.
It got dropped to a lesser, but it's still on its own. But this is just your maximums. This right here is the sentence. Okay. Does that make sense? You understand all that? All right. Any questions about this? This is what you want to do. Okay. Good. Ryan Morrow for Mr. Robert Willis, Your Honor. This is 21 CF 3281. This is going to be a negotiated plea on the VOP in that matter. The agreement of the parties contemplates that we'll ask the court to reinstate and modify the original terms of probation to add no contact with the alleged victim, in that case, Kawandra Coward, and the remainder of the probation shall be community control, $100 VOP fee, and $150 cost of defense. He was previously adjudicated, Your Honor, and the pre-sentence report won't be required. I'll pause and give Mr. Willis an opportunity to sign.
Harshfield should be next.
Is that the agreement?
It is the agreement, Your Honor. I do have the score sheet and the approach.
You may.
Hearts on.
Your Honor, he does not score, so this is not downward departure.
Thank you. May I approach with agreement, Your Honor?
You may. You okay with the score sheet?
Okay.
So, Mr. Willis, would you please raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
Okay, you heard your attorney state the terms of your plea agreement. Those same terms are contained in your written plea agreement that you've signed. First question is, did you read this plea agreement closely?
Yes, sir.
And did you go over it in detail with your attorney to make sure you understand the terms of it? Yes? You understand that by entering into this plea agreement, you're waiving the right to go to a trial and to contest this. You believe this plea agreement here is in your best interest? Okay. and you have had all your legal questions answered about this plea agreement?
Oh, if I pay off my restitution, can I get like early termination?
That's not in the written
That's
agreement.
not in here.
And the state will have a position on that?
The question was, can he terminate early? I think he has certain statutory rights to apply to that, and I couldn't stand in his way if I wanted to. So if he wants to apply to that within those rights, and it'll be to the court's
It's not
consideration.
automatic.
Right.
So, does that answer your question?
Yes, sir.
You still want to proceed? Okay. So, based upon that testimony, the court will accept your plea agreement. It's going to modify the original terms to add no contact with the victim, the John Brooke Cowell. Okay. I want to just explain to you this, because this is important. This is a one-way no contact. It's on you, it's not on her. So if she calls you on the phone and you pick up, you're in violation. She walks up to you in the store, who's in violation? You. I mean, and generally this doesn't really happen. A lot of people are all worried about somebody's going to trick me. It doesn't happen. If it happens, just walk away. I want you to understand that you have an affirmative obligation, and if you violate this no contact, they can put you back in an orange jumpsuit. I'm just telling you, they don't fool around with this stuff. On these type of charges, these no contacts are important. Are you clear about this? You done with that?
Yes, sir.
Okay? I don't want you to get in any more trouble. Okay? If you have any other questions, you got the remainder of the probation will be on community control. That's a lot more supervision. You have to pay attention so you don't violate. If you come back on when you violated community control, what happens? They're going to be asking for jail or prison. Okay? So you got to stay focused every day. You get up, stay in contact with your probation officer, and do the right thing, and get past this. Okay?
Yes, sir.
Any questions?
Yes, sir.
Thank you. Thank you very much.
Thank you. Did we call everything, or are we going to recall some? I'm a little bit lost now on what we're going to do with Gafford, Flannery, and Mr.
Well,
Taylor.
we've got, what I have is that we've got Flannery, who apparently that's got that warrant. Gafford, I don't know about Gafford. And then, what was the?
Mr. Taylor was the last one, but it sounds like we'll be seeing him on 7/18.
So I don't know about Gafford, but we can bring it back Flannery for sure.
Sure. Flannery will be next, Heather.
Yes, Mr. Hartzog before the court, if I can let him sign the plea agreement. Mr. Hartzog is before the court on the morning docket in 22 CF 2492, 22 CF 3036, 6.23, and then the afternoon docket in 23 CF 1112.
No.
I think you're fine.
Yes, Your Honor, if the court will allow me, I'm grabbing the score sheet out of my file. Mr. Hartzog and I reviewed it yesterday. We have no objection to the score sheet. The minimum guidelines listed on the score sheet is 20.7 months DOC.
So I may approach, Your Honor? You may. You say those were the points or the minimum DOC?
Minimum DOC.
Okay. Thank you.
Flannery's coming in just a second. Okay.
You're okay with the score sheet?
Yes, Your Honor, the score sheet is accurate and no objections.
Would you please announce the terms of the plea?
Yes, Your Honor. Mr. Hartzog will be entering a plea of no contest as charged in 23 CF 112. He'll be admitting the violations in both 22 CF 2492 and 22 CF 3036, be adjudicated guilty in all counts and cases, and 22 CF 2492 and 22 CF 3036, we're going to revoke and terminate the outstanding probation, sentence to 20.7 months, Department of Corrections, $100 cost of prosecution in each case, 150 public defender in one, and 100 public defender in the other. And then in 23 CF 1112, count one, the felony count be 20.7 months DOC with credit for all time served, concurrent. Count two, time served, standard court cost, public defender fee. Mr. Hartzog would ask for 24 months from date of release to pay those fees before they're sent to collections.
State.
That is correct, Your Honor.
Well, one point of clarification on here. It doesn't say anywhere on here revoke and terminate.
Yes, Your Honor, I realized that as I was reading it.
And I think that's important, you know, that I want to make that change. Mr. Hartzog, would you please raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
Okay, so you heard your attorney state the terms. You heard your attorney state the terms of your plea agreement.
Yes, sir.
And those same terms are in the plea agreement, the written plea agreement that you signed. And just one little technical thing that. So, my first question is, did you get a chance? Have you actually read this plea agreement?
Yes, sir.
And have you gone over it in detail with your attorney to make sure you understand all the terms and conditions on it?
I think so.
Okay. The main thing is that this thing really talks about, in addition to laying out the terms of the agreement, is that it talks about your rights, that you're waiving some valuable legal rights, the right to go to a trial, and to contest it, etc. This will be a final resolution in your case today. Do you understand that?
Yes, sir.
Okay. And you believe this is in your best interest to do this?
Yes, sir.
Okay, based upon that testimony, the court will accept your plea agreement. And on basically all your felony cases, you will be sentenced to 20.7 months DOC. They'll all run concurrent. You got your one misdemeanor, possession of paraphernalia that'll be credit for time served. You got a bunch of fees and costs. You will be done with your probation. You don't have to worry about that when you come out. You will have 24 months from the date of your release to pay any outstanding court costs before they're sent to collection. Okay. Any questions concerning any of that? No? Okay. And you do have, even though you just entered this, you do have 30 days to appeal this sentence. Okay? Good luck.
So what do we got? I'm running downstairs to get planners for you right now, sir. There was a miscommunication.
Okay. Is that our last one for this morning?
Yes, and we also have Gafford, but I don't know what the name is for the Gafford.
Do we still have Gafford here, though?
Yeah, he's in the cell right back there. Okay. Do you want him brought back out too?
Well, let's see what they got. I think we got to bring them out for something because we got to leave and continue. What are we doing on Gafford?
On Gafford, Your Honor, that was a case where we weren't sure if he was going to have housing in order to accept the CC offer and be successful, but he asserted to me at the podium that now he's got it squared away. So
Do you need
we're
to
hoping.
talk with him some more?
I don't really need to talk with him, but I do need to draft paperwork because we didn't come prepared to enter a plea today. If we could put him on the afternoon, I could definitely have the paperwork ready for the
Can we
afternoon.
bring him back in the afternoon to do a plea?
I'll let him know that.
As to Mr. Flannery, we had a written plea agreement ready to go, and now I'm not so certain that he's going to take that. I'm going to advise him this case offer will not change.
Ask him what he wants to do.
All right.
You're welcome, Mr. Harpo.
Hey, Heather, Gafford's going to be brought back.
Keep him today, you can be a judge. You know what you want to do.
We're going to take a lunch break right after Mr. Carson. parts on this guy.
Okay. Your Honor, speaking on Mr.
No good. They're bringing her over at 1:30.
No, it doesn't sound like it. Well, they added something to that, they which created it, but it's all within this same case.
I was planning just doing
Yes. Good afternoon, Your Honor. Sorry for that delay. This is Mr. Flannery. I'm speaking with him about the state's offer of Keaton, and I think I understand now where the confusion came in. It's my understanding his significant other's having some health issues, so he's not prepared to be inpatient for 12 full months, but he is interested in the drug court program. He's already had some time with Ms. Henderson and sat in at least once, but the anticipation was that he would be reinstated. So they did not move forward at that time, and I hadn't been involved up to that point, but now I will let Ms. Henderson know that he is interested in the program and would like to be fully evaluated. I'll get with the state and see if that's something that they can agree to.
So we'll just come back July?
July 18th will be fine, Your Honor, or the 11th,
Well,
whichever.
we'll come back on the 11th at 9 a.m. That's the soonest one.
Thank you, Your Honor.
Okay. Okay. If that's a wrap for this morning, and we'll